happy hours?
Yes, we are.
Very much, ma'am.
Good afternoon.
Okay. My name is Bongile Baloi. I'll be your facilitator for this class today. And the whole purpose is for us to get the practical application of the matrimonial property regime and the divorce regime. So it's going to be a very interactive class. I'd like to believe that you all have your guides with you, and I will go according to the guide because I like how the guide is structured. It starts with how you advise someone with regard to getting married, the types of marriage that they can enter into, the requirements of those marriages, and up until what entails in a marriage, what can you do, what are your rights, what are your obligations, up until to a point of divorce if it ends in a divorce, and what happens in a divorce matter, how to take notes, what should be included, and up until the end, which is in case where there is an order that has been granted or a decree of divorce, what do you do if there is that divorce decree? And if there is contempt, how do you deal with that? So I will be starting with my class. Are you all ready?
Yes, we
Yes.
are.
And you got my name correct. So how this is, so please, I would like for just as ground rules, let us mute so that we can hear each other properly. And if there is a question, I will recognize questions by hands. I will also open the floor for questions whenever I'm done, maybe with a subject matter. And then we'll take maybe 5-10 minutes comfort breaks in between, depending on how much we cover. You would have noticed that the scope is very big, but we also have a limited time to try and cover as much as possible today in order for you guys to have an insight into the whole MMD module and the practicality of it, because I know that we've all learned family law when we were doing our LLB, but now is how you're going to apply those legal principles that you have learned in varsity to the practice that you're going to be engaging yourself or getting yourself into. So to start off, I'd like to welcome everybody and say feel free to ask questions if you don't understand. If you get misled or you feel that you're not understanding what I'm saying, please raise your hand and then so that we can clarify. We are here to help each other. We are here to empower each other, and we are here to learn from each other. Okay, so we can start with our class then. Are you all ready? If you go to your
Yes.
first page on your study guide, which is advice on marriage, you will note that the first thing that the manual deals with is breach of promise. Can anyone tell me why that topic is the first topic above everything else that you need to learn in matrimonial law and divorce law? Anyone?
I think maybe it's because that's where everything else starts. Man.
Okay.
We start by promising each other that
Yes.
we're going to get married whenever,
Um,
and then you enter. If it materializes, then the marriage comes into being.
Mm-hmm.
That's
Thank you very much. So Patrick, if what you're saying that's where everything starts and that's where everything materializes, you start to promise each other. In your interpretation, what is a breach of promise?
a breach of promise. In my interpretation, it's when one doesn't honor what he promised to the other. You see. Then that's where we start talking of the breach of promise.
Okay, promising to the other. What exactly are you promising to the other?
In this
Marriage.
in this instance, it's
That you're gonna marry them.
to marry the other in some time to come.
Okay.
Mm.
You know what is important? Thank you very much. Sheila, Shelley, I will take your hand and then I'll proceed and explain what exactly does breach of promise entail in law and in practice.
Okay, based on my understanding, it's maybe based on historically, if a man proposed a woman for marriage, morally or based on public belief, it would be frowned upon for them to then go and change their mind, so to say. So when the law actually then you could actually sue somebody for breaking that promise, or legally there could be consequences for them breaking that promise. But where we find ourselves now is that times have changed, and it's now socially, and not just socially but financially as well, for you to now want somebody to have legal consequences for breaking a promise of marriage. In the current law, in modern law, it does not seem to hold water. So the courts now might not necessarily recognize that as a breach per se. And I think in the book they also refer to a case where that was the case.
Okay, thank you very much,
A very
Shelley.
summarized version of my.
Thank you so much for opening the floor for us. Basically, what breach of promise is, well, it used to be conceived as a concept where in people promise to marry each other, and then at some point along the line, the one changes their mind to say, "No, I don't want to marry you at all." But it's not just about, "No, I don't want to marry you at all." When you look into what the study guide is saying, and which is very true, there has to be a delictual component or delictual act that comes with that breach, to say that it's not just me saying I don't want to marry you, but it must come with what we call injuria, which is defamation of that person's character. If by saying I don't want to marry you doesn't change anything, doesn't defame you in any way, we cannot see that or deem that as a form of breach of promise. So you need to be very mindful of people who would come and say, but this person has promised to marry me and now they are changing their mind. You need to look into the delictual component into it, whether or not was there any form of breach which is a wrongful act, which also brings about damages in either in the esteem of the person, or is bringing about a wounding that person, physically, emotionally. That's where the injuria part of it comes in. That is the very most important component of a breach of promise. It's not just based, because, like you are saying, Shirley, that times have changed. People promise each other. You can't just be engaged to someone and then they change their mind and say that that is a breach of promise. You need to go deeper and prove in law how that promise has been breached, and what damage has it caused to you. They refer here to the case of Van Jaarsveld and versus Bridges, where it says that Mrs. Bridges sued Mr. Van Jaarsveld for damages under the two heads, namely injuria and breach of contract. The parties got engaged in 2005 and set the wedding for 2006. However, in December 2005, Mr. Van Jaarsveld sent Ms. Bridge an SMS informing her that he was terminating the engagement. Mr. Van Jaarsveld was a young bachelor farmer, whilst Mrs. Bridge had four unsuccessful marriages during the existence of the last of which her relationship with Mr. Van Jaarsveld started. Less than a month after termination of the breach of promise, less than a month, the court found that the breach of promise to marry could lead to sentimental damages if only it was wrongful in a delictual sense, which is what I was referring to. By delict, remember, it deals with damages to your person, to your life, to your esteem, to your personality, to how people perceive you. If that promise did not go that far, so as to damage to that extent, you cannot come thereafter and say, I want to file for or sue for breach of promise. You have to prove that it was contra bonis mores, or it was against every delictual, all the delictual elements. that you need to prove in a case of village. So it must be in line with the delictual claim. Otherwise, you will not succeed with trying to prove your claim for breach of promise. Do you understand?
Yes, we do.
Yes.
Are we all in the same line? So you can't just come and say, no, I want to sue this person because they are now refusing to marry me. You have to really have a strong and concrete case to prove before the court that indeed this is how I've been defamed in the society, in my profession, in my life, in my circumstances. It has changed me to a worse off position to where I was. If not, then there's no way that the court can grant an order in favor of you if you are the applicant in that matter. Can we move along on that one? Are we clear? Okay.
Yes.
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 Oh, okay. Now moving along, we started with when parties started to promise each other that they want to marry each other, but they're changing. Let's take, for instance, now they agree that the parties come to your office to say, we want to get married, but we don't know what type of marriages we want to enter into.
No, ma'am, can
In
I?
our country, and according to South African law, we have got three types of marriages. Can anyone name them for me?
Hello, ma'am, can I
Is it?
ask, please? Ma'am,
Yes, yes, sir.
I just want to
Marriage,
understand. Can you
Yes,
hear
you
me
are
now?
not audible enough.
Can you hear me now?
I say customary marriage,
Yeah.
civil marriages, and
Can you hear me now?
No, I can't hear you.
civil marriage, customary marriage, and civil union.
Civil marriage, customary marriage, and civil union. Yes, that's correct.
Hindu marriages and Muslim
Pardon?
marriages. Hindu marriages and Muslim marriages.
Are they recognized in South Africa as the three major?
No, no, they are not.
Okay, we will get to that. Remember, there's general rules and there's exceptions to all the general rules in law. So we will deal with that. It's not that they are not recognized as marriages, but they are marriages in our country in that, but we will deal with the legalities of those marriages as we go along, and then you will start to understand why they are not necessarily referred to as the three major marriages that we find in terms of South African law. So as I go along, you will understand what I meant. Donay, you've got your hand up. Donay, I will move. Okay, yes, it is correct. We have three types of marriages. We've got a civil marriage. It is a
Sorry,
marriage that
sorry, Spongile, before you move.
May I?
Spongile, before you move, you've got a bit of static and it's making it a bit difficult to hear.
Yeah, I'm also struggling to hear her.
is it? Are you
Yes.
struggling to hear me?
You were clear before, but now all of a sudden you've got static and we can't hear you.
Yeah, it's
I, I
not
just
easy.
I just you know what? If a lot of people are not muted, it sort of disturbs the whole system. So if you can mute yourself and unmute only when you want to say something, then it will make the sound much better. There's a few people that are not muted. Am I still static?
Now
No,
you're
you are not. It's
perfect.
fine now.
You're
Is it
good
fine?
now.
Yeah,
No, you're
please. If
not.
we can just
Sorry, I
unmute
found you a
ourselves.
little bit. Hi, Sabingil. I found you a little bit muffled. Your voice
My voice
muffled,
is
a bit
muffled.
muffled. Yeah, it's not clear.
Is it?
I'm not sure
Still,
about the rest of the group.
Yeah, it's like you are too close to the speaker,
Yeah.
is
the
it?
mouthpiece or something.
And now?
It is very clear.
I don't know.
Right, please
Can
continue speaking.
pardon?
Spongile,
Can
you
you
are
It
hear
is
me?
clear.
very
Continue
clear. You can
speaking.
continue speaking.
I don't want anyone to be left behind. Can you hear me now?
Yes, we can hear you
Yes,
now.
we can hear you.
It's much better.
Yes, we can hear you, ma'am.
Okay, can you proceed then? Donay, you had your hand up.
Yes, please.
Okay,
Yes,
thank
you may
you. I
proceed.
see
I wanted
there's
to
a
ask a
time.
question for clarity.
Thank you very much.
The
Okay,
three
Please just get a clarity on the topic you just chat on us.
if
May,
you
may I please
want
ask a
to
question for a
we'll go
question
to
of
the chat.
clarity?
You wanted to clarify something?
Hello, can I? Yeah, I just wanted to get clarity.
Mm-hmm. Yes, you may proceed.
You know, when somebody has engaged you. Yes, when somebody, yeah, that you in what you mean is that you cannot challenge a person that he is with, that can only challenge a person on the basis of intellectual damages. I'm not so sure if I was like clear by what you were explaining.
I can't hear you. You're saying someone is
Yeah, well,
engaged.
I've got I'm going to proceed. Now, I'm saying when a breach of promise has taken place, you cannot challenge that, but you can only challenge the intellectual damages that the person has suffered.
No,
Is that
you
what
you can challenge that, but it has to be linked to the delictual components or elements. If there is no delictual component that has been suffered by the claimant, then you cannot prove to court that there was a clear breach of promise. So the breach of promise doesn't just come alone as a breach of promise, but it's a breach of promise that is linked to a delictual claim, which means it comes as a delictual claim. There has to have been some form of damage that you have suffered, and you must be able to prove substantially to the court what damage you have suffered as a result of the breach of promise. To say that your feelings were hurt is not enough to convince the court to say that you have suffered any form of breach. A breach that you can suffer, it can be financial breach, it can be maybe what do you call this, defamation of your character, your persona, your lifestyle. If it has changed from the worst of, I mean, from a better condition to a worst of condition, that it degrades you from the community or from people around you, then you can be able to succeed depending on the circumstances, obviously, of your case. Then you can be able to prove in that instance a breach of promise or a claim
thanks,
for
ma'am. I'm
breach of
clarified.
promise. Okay,
I'm
thank you very
clarified.
much.
Thank you very much.
Thank you very much.
Thanks.
Okay, okay. While we move forward, yes, you. There was someone who was telling us that there is three forms of marriages in which we're going to be mainly dealing with, which is the civil marriage that is um, it's under the Marriage Act of 25 of 1961, and then we have a civil union, which is a union that is governed by the Civil Union Act 17 of 2006, and we also have the Customary Marriages Act, which is governed by the Recognition of Customary Act. Now, to start with a civil marriage, what is a civil marriage under the Marriages Act? It is important to know that parties in a civil marriage cannot enter into a customary marriage. That's what the law says. So if you enter into what we refer to as civil marriage is usually when people go to Home Affairs and sign before a marriage officer, or people getting married, and then there's a marriage officer who comes and solemnizes that marriage, and then it's between a man and a woman who are of 18 years and above. If it's in case of minors, there has to be consent from the guardians or the parents, or if the guardians or the parents of the minor children don't want to consent to the marriage, they can approach the Minister of Home Affairs. If that also doesn't succeed and they so much want to marry each other, they can also appear, they can also approach the High Court for a permission to get married, obviously based on the circumstances that they would have presented before the court. So now this is just a normal marriage where we are so used to people are getting married and we see them signing in front of a minister or a pastor or a marriage officer or whoever will be there to solemnize that marriage. So that is what we refer to as a normal civil marriage. And then there is very silly requirements that they say for a marriage, a civil marriage to be valid, it must be done in an enclosed environment. I mean, people get married outside, in parks, at the beach, wherever they choose to be. So that falls away. And if that doesn't happen, that doesn't mean that the marriage is not legal or is not legally recognizable or it can be nullified based on the fact that as long as the requirements are met, that the people have proper consent to the marriage and there is a marriage officer who is legally entitled to or legally qualified or whichever way with the marriage officers can solemnize the marriage, then that marriage becomes a valid civil marriage. So that is the basic and simple explanation of a civil marriage. Now we come to the customary marriage. Customary marriages are very complex. I think you would have noted there's been cases and cases over cases that deal with different issues from different cultural backgrounds and the requirements thereof are not dealt with within the same way in the whole African cultural system, but each and every ethnic group has its own way in which they solemnize or they formally acknowledge that this is a valid customary marriage. Now, to start off with the customary, I think we should take it easy here because this is where a lot of things are and a lot of uncertainties and a lot of inconsistencies regarding customary marriages are found. Even though we may know that there is the Recognition of Customary Marriages Act of, I think it came in 15 November 2000. That's when they differentiate between customary marriages that were entered into before the coming into effect of that act and customary marriages that came after that act. Just to give you a brief background, if you entered into a customary marriage before the coming into effect of the Recognition of Customary Marriages Act, which is before the 15th of November 2000. Let's say it was the 14th of November 2000. Those marriages were still considered as marriages in terms of the respective ethical groups as customary marriages and were therefore regarded as marriages out of community of property when this Recognition of Customary Marriages Act came into effect. Now, all marriages that came or that were performed after the 15th or from the 15th of November 2000 were recognized as marriages in community of property. For parties to exclude the community of property, they have to sign an antenuptial contract before they enter into a customary marriage. Are we still together?
Yeah.
Can you please
Yes.
repeat the date?
Yes.
The date
Are you
of,
following?
Yes,
can you
we
please
are.
repeat the date, please?
Okay. So now the Recognition of Customary Marriages Act did not just come in, but there was also an amendment that was done in 2021, which we will deal with, that refers to Section 7.1 of the Recognition of Customary Marriages Act. Now, in terms of this legislation, there is requirements that a marriage or a marriage to be recognized as customary marriage must meet, and people always try to confuse the whole requirements with what different cultural groups adhere to. The major requirements for a valid customary marriage in order for it to be recognized is that one, the both parties who are entering into this marriage must be 18 or above. Number 2, there must be consent to get married according to customary law between these two people. And number 3, it must be entered into, negotiated, and celebrated according to customary law. Do you understand that?
Yes.
Yeah.
Yes, we do.
Any questions so far?
No.
Okay. Now, the Recognition of Customary Marriages Act.
I have a question.
Yes.
Sorry.
Go ahead.
With regards to customary law,
Yes.
is it necessary to go and sign at Home Affairs?
Sign how? Because when you
So
sign at
you-
Home Affairs, it's
Yeah.
either you are now converting your customary marriage into a civil marriage, or do you refer to the registration of the marriage?
Yes,
may-
yes. I'm referring to the registration of the marriage at Home Affairs.
You can registration of a customary marriage. It doesn't nullify the marriage even if it's not registered. But you can still go and register the customary marriage with Home Affairs, and you'll have a marriage certificate that says customary marriage.
Okay. All right. Thank you.
But sometimes people will go there with the idea of going to register, and you find that, especially when the act was introduced in its initial stages, people would go and register the marriage with the Home Affairs, but then they would make them sign a civil marriage. So there was a bit of a confusion between the two. How does registration and signing affect the customary marriage?
Okay. So just to be clear, they wouldn't go to Home Affairs and sign because that would convert the marriage into a civil marriage as opposed to a customary marriage, but they can register the marriage.
You can register the marriage with the Home Affairs, yes.
Okay, thank you.
Okay, thank you.
Question, please.
Yes.
It's with regard to the last requirement that says that the marriage must be negotiated and entered into or celebrated in accordance with customary law. So what happens if both parties are coming from different ethnic groups like Zulu and Venda? So the question is that which law will be recognized as the law when the marriage was entered into?
There is a concept called lex fori. I don't know if you know about it. It's normally a term that is used when there is conflict of laws. The lex fori law would say that the law of the husband at the time of the marriage will take precedent. You understand?
Okay. Yeah, I do. I'm clear.
So
Thank
it's
you so
called
much.
lex fori. It's used in cases of conflict of laws. And we've had this in South Africa, quite a number of cases where it's customary marriages, but there is difference in cultural celebration, negotiation, and then they look at the law of the husband at the time of the marriage.
All right, very clear. Thank you so much.
Okay.
But ma'am, can I also get
Can
a
I
clarification?
have hands, please? Can I recognize hands?
Hello.
And then we don't speak over each other.
I just want to.
Is it Alpheus?
Ignatius.
Yes, I just want to check something here with regard to the issue of the antenuptial contract before you get into marriage, which is customary. That in the antenuptial contract, well, my understanding that you can put anything as long as it is not against the law, and of course, if it does not prejudice the other party. But I would just want to check if we can include a clause that deals about one not taking responsibility for maintenance in an event that we get divorced or there's a breakup there's a breakdown in the marriage. Well, that's one question that I wanted to ask.
But Mr. Matebula deals with the proprietary consequences. It deals with the assets of the parties, but not issues of maintenance and things like that. Because remember, there is laws that govern maintenance, and you cannot, unless if you are saying in your ANC you're going to exclude maintenance of each other, maybe that could be applicable. But anti-neutral contract is meant to deal with the proprietary consequences of assets within that marriage, but not with issues of maybe children or maintenance or things like that. No, but how you're going to deal with your assets in cases of death or in cases of divorce. Did I answer your question, Mr. Matebula? Okay. Eric, there is a hand from Eric.
Yes. I just wanted to check.
Thank you. Yes.
Hello?
Yes, I can hear you, Eric.
Okay. I just wanted to check with regard to the benchmark of the 15th of November 2000, customary marriage, more especially customary marriage before. I think if I heard you clearly, you said it's recognized as out of community of property. Can you perhaps clarify on that?
It used to be, but remember, there's been an amendment on I think it's a 2021 amendment of Section 7(1) of the Recognition of Customary Marriages Act, which was in conflict with Section 2. With Section 6, which Section 6 deals with issues of equality in the marriage, but then Section 7(1) sort of excluded the people who got married before the coming into effect of the recognition of customary marriages, meaning people that got married before the 15th of November 2000. But you will understand it as we go about dealing with that, because it is something that I'm going to deal with in extensively, so that you understand what the amendment has brought into picture and how it has changed and made this customary recognition of customary marriages to evolve, not to be a stagnant law that is so rigid. Because remember, customary law it evolves with time, so things are changing as we go along. From constitutional court cases, we see there is a change in how things are done and how customary issues are dealt with. So that is how the law is evolving. So we can't be saying that. The reason I stated that, I said that at the initial stage of the recognition of customary marriages act, that was the position, that if you were married before the act came into effect, therefore your marriage was deemed to be completely out of community of property. But if you entered into a customary marriage after the 15th of November 2000, then your marriage is deemed to be in community of property, unless if you sign an ANC to exclude the community of property.
Yeah, no,
do you understand, Mr. Mkapa?
Yeah, no, I do understand. Thank you.
Thank you very much. I see there's Ignatius.
Yes, ma'am. I just want to comment with respect to when a marriage is taking place, a customary marriage is taking place. Well, remember that when a man goes to marry a woman, you are going to negotiate in the ball to the woman's side. So obviously, it's the woman's culture that will take effect, because you're going with your family to negotiate to marry the woman in question. So whatever that is going to be done with respect to the marriage at the time of that marriage should at least be in the culture of the woman. Let's say, for instance, in KwaZulu-Natal, or maybe in any other part of the country, any other province or stuff. So that particular culture will subsist. That's what my understanding is all about. maybe after the marriage, that is when the culture of the husband then will have to take over.
No, but remember, here we're speaking of conflict of laws. So when there is conflict of laws or conflict of cultures, there has to be a dominant culture, right? So
Yes.
yes, so that's why I referred you to the Lex Fori, which is a principle that applies in case of conflict of laws, to say the law of the husband at the time of marriage will take effect if there is conflict in that case. I'll give you an example. For instance, there was a couple that there was a dispute over pension and some monies from work of one of the cases I've come across. Now, in that case, it's Ndebele. They were both Ndebele culture. Both of them, the husband and the wife, were from the Ndebele culture. The wife, the alleged wife, came with a lobola letter, which says that they had paid the husband to be had paid 10,000 rand towards lobola for the lady. Now that's where it ended, and then they say they would come back. Now that's where it ended. Unfortunately, the guy passed away, and then when he passed away, he left beneficiaries to his benefits at work to be the mother, his mother, and his daughter. And then the lady came and said, "But I have this lobola letter, and I'm married to this guy customarily, and he used to look after me. This is what he used to do for me." Now we had to determine whether or not there was a valid customary marriage that existed between the two, because according to the guy's family or the deceased family, there is certain rituals that needs to take place, and there is certain cultural activities that needs to be done in order for a wife to be recognized as a wife and for that marriage to be considered as a wife. I think they said there was a culture called Isimanje, wherein the woman, after they've paid lobola, after they've celebrated that, needs to go and meet the elders from the husband's side, the female elders from the husband's side, who are going to take her through what marriage means in the Ndebele culture or in the Ndebele culture, how she should look after her husband. I mean, that's to give sort of commands on how you should carry yourself as a wife. So that process never took place, and that marriage was thrown away out of court, because that process, which is very, very important in the Ndebele culture, did not take place, and the lobola was not even finished. In the Zulus, you'll have things like inyongo, ukuthelelwa inyongo, what you call, I think it's called bile, that green thing that you find in an animal. In chicken we have it, in cows you have it. They call it inyongo. If the woman was not poured with that, that's a very significant ritual that needs to take place within that particular culture. So if that culture does not take that practice is not done, that woman is not fully recognized as a wife, then there could also be challenges to challenge the marriage, whether or not that customary marriage is valid or not. So when we come to conflict, it's things like that that we always meet the conflict from. So I don't know if you understand that. I think I've lost him. There's a hand from Miss Matlango, and then there's a hand from Mabatu. I'll take those two and then I'll proceed.
Yes, I just wanted to check one thing, in terms of the registration of customary marriage.
Yes.
What are the implications thereof if you register? Because I heard you saying that you can register a customary marriage or you can convert it into a civil marriage. If I'm not sure whether I heard you clearly there.
No, the question that was asked was signing at the Home Affairs and registration.
Yes.
So there's a difference between the two. If you enter into a civil marriage, you go and sign with a marriage officer, and then that's it. You sign, you have your witnesses. With the customary marriage, you have a customary marriage that has been concluded between the two families, you now go and register that marriage with Home Affairs. So the implications wouldn't be there. Even if you don't register the marriage, you still does not qualify that marriage. It's still a valid customary marriage. So registration is not a requirement for the validation of a customary marriage.
Okay.
You do it for convenience sake, just in case someone dies or someone decides to divorce, to say, but we have a marriage certificate which says we are married under customary marriage.
Okay.
I took two hands. I said Mr. Mahlangu, Miss Mahlangu, and Maratu, and then those will be the last hands, and then we can proceed.
Bongile, I just wanted to ask, because you mentioned that ANC must be concluded before customary marriage. So what are the effects of concluding ANC after customary
The effect
marriage?
is that you have to go through the whole process now of changing from a matrimonial regime, of which means once you conclude a customary marriage, it's automatically in community of property. So if you want to exclude community of property, you have to do the ANC before the whole Nilibobola negotiation starts. So that your marriage will be, yes.
Yes, no, I see that being the trend. The trend where people are concluding an ANC afterwards. So what does that mean? So it means, what does it mean in terms of so would that ANC be recognized, or these people are still married customarily? I mean, what are the effects of that?
Those people are married customarily, and they are married in community of property. There's a process in which they need to follow in order to solemnize their marriage as out of community of property. But like I said, that you know what, to every general rule there is exceptions. There are those circumstances where you find that the intention initially was to marry out of community of property, and now grapes are sour. A and J, they no longer see eye to eye. They want to divorce, and they realize that, oops, this thing is not registered with the notary public and in the deeds office, but it was our intention. Therefore, you can use that. You can convince the court that the intention, as long as both parties are in agreement that it was our intention to enter into a marriage out of community of property, and they lived their lives that way as if they were married out of community of property, then the court can consider that ANC to be valid.
All right. Okay. Thank you.
But to avoid all of that, is just to register the ANC first before you enter into a customary marriage. Mabatu, you'll be the last hand, and then I can proceed.
That was me. Thank you.
Oh, okay. I think there's Miss Mahlangu. That was the last one.
No, it's fine. I think I didn't lower my hand thereafter I spoke to you.
Oh, okay. I think also the other Mr. Mkari is a historic hand. Can you please put it down? And Maba to put your hand down. Thank you very much. I was just about to say that the Recognition of Customary Marriages Act recognizes marriage that are valid under customary law and existed before the 15th of November, or that the customary marriages entered into after 2000 that comply with the provisions of the Act. So the recognition applies to each of a person's customary marriage where a person is a spouse in more than one customary marriage. The Act allows a person to have more than one marriage with different persons at the same time, which means the Act allows for polygamous marriages to take place. Unlike with a civil marriage, you cannot be in a civil marriage and also be in a customary marriage. You need to follow certain procedures in order for you to have a validly solemnized customary marriage. I don't know if you understand what that means.
Hello,
So can you please explain?
Is
Can you
it
please
who's
explain?
that? Is it Eric?
No, it's not me.
Miss Bomile?
No, it's me, Ignatius.
I'm checking the hands on the grid. I can't see anyone who has raised. It's only Eric who has a historic hand.
Yes,
Lion?
I raised my hand.
Lion?
Hello? Hello?
Yes, is it
Lion,
Lion?
hello, how are you, ma'am?
I'm good. How are you?
All right. On the topic that you're on, it's a very interesting topic. I'd like to ask something just to get clarity. You are saying that you could be in a civil marriage, and then if you want to enter into an additional customary marriage, there are other avenues or other steps that you need to be taking in order to have that additional customary marriage. Did I hear you correctly?
You heard me very correct.
Okay, so what are these steps that you are referring to?
Okay, you need to make an application to court first. There must be a court order that allows you to enter into marriage, to enter into a customary marriage. You see, the thing is, when the civil marriages were enacted, there was no recognition of our own customary marriages. Hence, women were deemed to be minors and were deemed to be unequal to their husbands and all of that. So there's still that thing that says that because of you entered into a civil marriage, therefore you can't take another wife before you divorce or before the other one dies. Or else you have to follow the procedure of applying to court so that you can be given an order to say you are allowed to take another wife.
Okay, no, that makes sense. Okay, thank you, Manbalo.
Okay, thank you. Eric?
Yes, I just wanted to understand something in terms of polygamy.
Yes.
If you've got more than one wife, polygamy. Okay, yeah, you've got more than one wife, and then in terms of registration, are you allowed to register all the three wives to the Home Affairs?
Yes, remember polygamous marriages can be legal if all marriages that are subsequent to that are customary marriages.
Yes, I'm talking about that.
So if you're in a polygamous marriage, it means the first, let's say you are marrying wife number 3, wife number 2 and wife number 1 must have been married to you in terms of customary law.
Yes.
So you can register that marriage as a customary marriage. It is allowed to register that marriage as a customary marriage. And so it is recognizable as a valid marriage in terms of customary law. Either you register it or you don't.
So I can register with the 3 wives?
Yes, you can register all the 3 wives. As long as they are married in terms of customary law, all of them. None of them is married to you in a civil marriage.
Oh, okay. So follow up to that. Do they have to have, each wife has to have the marriage certificate, which is me and the first wife, me and the second wife, or it should be one marriage certificate for all the 3?
Remember, you don't marry them at the same time. You might decide to marry one this year and marry another one in the next 5 years. So each and every one of them has to have their own marriage. Remember, certificate. Remember, these things also have consequences, patrimonial consequences in terms of death or divorce. So you need to cover, if you're covering 1, 2, why not cover the 3rd one? You know, so it's not going to be one marriage certificate with 3, 4, 5 wives. You want to have different registrations with different wives.
All right, no, I'm answered. Thank you.
Thank you very much. All right. While on the issue of the requirements that I've been dealing with, there is always an issue of saying, but lobolo is a very significant thing. Why is it not made a requirement? Lobola is not a requirement for a valid customary marriage. The 3 other requirements are the major components of a valid customary marriage. So but though we must be mindful of the fact that lobola is a very integral and important component in African culture. So in other cultures, they might say that, but because lobola was not paid at all, therefore we don't recognize this wife as our customary bride. Or in some instances, there's the issue of you have to deliver the bride to the groom's home. If or that celebration or that component did not take place, then they don't recognize you as a customary wife. So different cultures have different denominations, different cultural activities that they do that differ from other ethnic groups. So each and every ethnic group sort of has its own or similar ways in which they validate a marriage. So this type of celebration and celebration, negotiation, that's the most integral part because that's where they speak of intentions and the meeting of the minds of the family. If there was never meeting of the minds by the family where they say, okay, now we are doing it manje because we are Ndereles or we are not doing it. If there is no meeting of the minds there is no way that that marriage can be regarded as valid marriage because there is something that is still lacking there that has not been done. I don't know if you understand me. You will remember also there was also the case of what's that guy's he used to be a singer, Nsambo and Singadi.
And
Double
Remember
HP.
Double HP.
Double HP. Remember that they were the groom's family was disputing the marriage to be inexistent, but the Supreme Court of Appeal found that in that instance the handing over of the bride was an important element, but not to a key determinant of a valid customary law. Meaning, it's not necessarily a requirement for customary marriage. However, in that culture, the delivering of the bride is a very most important component. And in that instance, the bride was delivered to the household of the deceased, and therefore that's why the court ruled in favor of Ms. Singadi in that instance. I don't know if most of you remember that case. You can Google it, you can find it in your notes. It's one of the most prominent cases that we've had in as far as customary marriages are concerned. I remember there was another case, I can't remember out of my head, but it was unreported. It used to be the CEO of MTN. There was an engagement party, bought gifts for the in laws and everything. And then things went sour. When things started going sour, the wife said, I want to divorce. The husband said, no. The guy said, no, divorce, we were never married. The wife said, but I've got pictures here, we were celebrating. The husband said, but that was just a mere engagement. There was never a lobola that was paid. There was never any gifts that were exchanged. I bought gifts for your family, but they never did what is done in my culture. So that marriage was found not to be in line with the requirements of a valid customary marriage. So you need to be very careful how you approach the whole issue of negotiation, celebration, and all those elements because that's the most important component. In most cases, parties would have agreed to enter into a customary marriage. Parties would have been majors or 18 and above. But always the problem when it comes to issues of divorce or death is where the third requirement is, which is negotiation and celebration and all of that. That's where you find that there is mostly a conflict when it comes to different ethnic groups and different cultural groups. So, Daddy, you've got a hand up.
Hi, yes. I wanted to find out. I've read the requirements of the customary marriage, so I'm thinking if one of the requirements is not met, let's say both spouses consent to be married to each other and the marriage is negotiated, but there is no celebration. Is that a valid customary marriage? And
It's
if
not
ever
valid.
there is, yes, and
It's
if
not
ever there,
valid. You must meet all the three requirements fully.
okay. And then another question is that if ever there is a celebration, um, how do we prove that in court? Let's say maybe there's a dispute regarding the celebration. Maybe the two requirements are met, but the third one, there's a dispute regarding the celebration.
Do we use
the either if it is intense like that, it depends on the parties themselves. Experts in the cultural that particular ethnic group will be called in, or expert opinion will be sought out in order for the courts to really come to a conclusion as to was it a valid or were all the requirements met in terms of the law of the husband or the wife in that instance. So usually you would have to get an expert in that field, in that language, to say come, or in maybe in marriage, African marriages, we used to have people like what Professor Maitusi, we used to have like what Professor Ndima. Those are the people that we know within the legal fraternity that they are experts in cultural issues. Then they are normally called as witnesses to come and testify and give full, even chiefs or Hindunas or whoever are involved in those places. In the rural, in the urban areas, then you find those experts who will come and testify before the court. Then the court, on balance of probabilities, will have to find in favor of whoever.
But nowadays that we have pictures and videos that can help as well with regards to proof of
but that you can have pictures and videos. Like I gave you an example of the one case that I was dealing with, where there was pictures and videos to say this was it. The guy said, but this was an engagement. In my culture, this is not how we celebrate a customary marriage. In my culture, this is how we celebrate a customary marriage. As far as I'm concerned, we are just engaged, but we are not married customarily. Therefore, we cannot decide to say that you are divorcing me. So there was a divorce, then he raised a special plea to say that there's no existing marriage between him and the wife. And the court found in his favor to say that, but according to his culture, that's not how it's done. In his culture, this is how lobola negotiations go. So this was just a lavish engagement party, and it was not even near a customary marriage. So that's what I mean by that.
Yeah.
Okay.
Okay, thank you, ma'am.
Okay, thank you. Was it Ignatius?
Yes, yes.
Okay, you can put your hand down.
All right, ma'am.
Okay. While on the issue of the customary marriage, I think
I'm here. I raised my hand before I
Sorry
you
to
proceed.
interject. I
no,
raised my
but
hand.
you just I see it on the grid. If you raise your hand, I should see it on the grid. If I don't see it on the grid, then I will pass you. Yes, Connie.
I did raise my hand.
Okay.
May I please?
Can I have Connie first, and then Didi will be the next, and then I will continue from there.
No, ma'am, I've been raising my hand. I haven't been given a chance. And I also
Who is that? Is it
that yes.
Yeah, mine
Can
is
you
also
start now?
up for a while.
Yes, Lirato, you can go first.
Yes, ma'am. I wanted to ask a question in relation to a person dying like WHP, and then they started fighting that they were not married. Isn't that the court looks at also the intention of the person that was getting married? Because remember now, the minute you go and negotiate and pay lobola, you are intending to marry this person, and before you die, you never said that you are not marrying this person. So how is it that they can say it's not concluded customary marriage, but the intention was to actually marry this person and do everything else that was supposed to be done? What happens in that way, in that sense?
If a person, you're saying if a person is deceased and there is a dispute over the marriage.
Yes.
And then?
I'm asking, don't they look at the intention of the deceased, that that person was intending to marry this person, but death came before that time. And
but
now,
remember,
in actual fact,
remember, like in the ensemble case, the deceased was not there to speak for himself, but his family was there to speak for himself, to speak for him, because there was an estate that was in question, which they didn't want the wife to benefit from. Hence, they were saying she was not married customarily to him. So they had to go deep into the culture of the Sambo, which is, I think, Mozambican, and exactly what is it that in the Tambo culture they do. And the court found that no, all the requirements in terms of their cultural beliefs and practices met the requirements in which the applicant was raising. Hence, the court found in her favor. So if a person is deceased and the intention, you will not know. Sometimes, like the one that I gave you the first instance, to say he passed away before he could finish or do everything else. He just paid 10,000 rand, and then they said they will come back. And then now the woman is even wearing the black clothes to say, but I want to mourn my husband. He married me. And the husband's family is saying, no, but this and this and this did not take place. Therefore, we don't recognize you as a wife. And that matter has been in the High Court, and they found in favor of the husband's family because they couldn't prove any other thing except that lobola was paid. And in their culture, it's not just lobola that is significant for a customary marriage to be valid and properly recognized, but there are other practices which would have taken place that did not take place. And it took a lot. The other question was, why did it take the deceased so long not to do that? Because from the time he went to pay the first part of the lobola to his death, there was a period of like 7 years. And the question was, but if we talk of the intention and the meeting of the minds, where was the intention if for 7 years he did not finish paying lobola, but he went and impregnated another woman? So a whole lot of things are looked into case by case. So it's not one size fits all when it comes to customary marriages. Unlike civil marriages, where you know that it's a simple, straightforward thing. If parties no longer want to be with each other, the marriage has irretrievably broken down. Therefore, there is no marriage. But in this instance, you have to go deep and prove that in terms of this ethnic group, in terms of this cultural group, this is how we do things.
Because so now you're saying time also plays a role in this whole situation. If you take too long to
Not
go,
necessarily, like I'm saying, Lirato, that it depends on one culture to the other. You know what I mean? And on the circumstances of that particular case. So you can't use one rule over other cases. You have to look into each and every case as it comes before you, and then you can make a determination as a presiding officer.
Okay, thank you, ma'am. I'm answered.
Okay, thank you. Didi, you had your hand up.
Good evening. Firstly, may I request that the participants, when they finish speaking, they mute because it's quite difficult to hear you when you speak if they don't mute their speakers. The second thing that I wanted to say regarding the customary marriage thing, I think just to add on, I don't know if I'm right, you'll correct me. There was a case about, it's the Bunywa case or something like that, where the guy that intended to marry the lady, he had already negotiated for lobola, but the other requirements were not met yet, and then the lady got part of the guy's estate.
Like I'm saying that, it depends from case to case. It could have been that lady succeeded in her case. What were the circumstances surrounding that? What were the reasoning behind the court to say we are finding in favor of this person? So yes.
Oh yes, it's because they were also living together. That's another thing.
So you don't just look at one thing. You look at a whole. You look at it holistically. For instance, if you can prove that this person, how can you say that this person was not my husband when he was looking after me, paying for this, doing this for me, doing that for me? So if you find a presiding officer who would be on balance of probabilities, find that okay, this I can recognize as a customary marriage, then he might rule in your favor. So it really depends on each case's circumstances, how the court is presented with the facts and what are the surrounding circumstances of that case for the court. Because if you look at most of these cases, they are completely different. It's not they're not similar in facts and in the findings. So it's a very difficult space to work in if you're a judge or a magistrate in this case, because you have to go very deep and you have to have convincing evidence on balance of probabilities that then on balance of probability, I find that this is more probable to believe than this version. Therefore, the judge or the magistrate will go with the version that is more probable and more convincing to the court. We still have a long way to go when it comes to customary marriages. We're not at that place where we say, yes, this has been met, therefore it is a customary marriage. There's still a whole lot of disputes that are going to come, as we go along. I'll give you an example, for instance, the case of Somizi and Mohale. We also the Malovola being paid, though it was a civil union. We also Mahali being paid. You saw gifts being exchanged. You saw customary marriage taking place in terms the intention, the celebration from both sides. But then here comes the other partner to say, no, that was just for TV content. There was nothing about it. And then what do you say? When you go to court, you say, no, but that was just for TV content. We signed a contract to say that this is what we're going to be doing, but it was not really our intention, So it's things like that that the court will have to look at, okay, it was just for TV content. What's this TV content? How did it benefit the two parties? How does it bring about a marriage? Can we say a marriage can come out of TV content? And, you have to weigh all those circumstances and look at the surrounding circumstances, whether or not it could amount to a valid customary marriage. That is recognizable. I don't know if I've answered you, Didi.
Yes, you have. Thank you.
Okay. Thank you. I'll take Connie and then I'll move.
Thank you, Sbongile. Mine is regard to that court case where the marriage was not recognized after a woman proved through photographs that they were married, and the husband said it was just an engagement. So I want to find out in the event that the woman and her family were not fully informed of the processes which is recognized by the husband's family to recognize her as being married into their family. If there was no information passed through to the other party, would it be challenged that the husband, he intentionally omitted this significant information so that at a later stage when it is needed for him, he would turn around and say, oh, but that was just for celebration and nothing to do with the marriage, because we have not concluded this process we consider in our family as a marriage. Because now the challenge, for the woman, it comes to whether was she aware, was she informed, and what was the intention? Or maybe it could have been an omission, I don't want to say a negligent omission, but the husband could have maybe also forgotten about this. Couldn't it be challenged, or can't it be challenged? Because surely the woman should have been informed of these processes, and maybe the two families would have started the process to be concluded to the end. I'm just checking the possibility of when a woman is not informed or the other party is not informed to say, for you to be recognized into our marriage, this is what you have to fully go through up until to the last stage.
Thank you very much, Didi, for that question. Didi, you will realize when you're in practice. It's Connie. Oh, sorry, Connie. Didi, you can put your hand down. Connie, you will realize in practice, you will see things, and some of these things, they sound very unrealistic, but once you see it in reality, when people are in love, they are so blindly in love, they forget the most important things that could get them somewhere. And it's unfortunate because even it's Dabengwa. If you can Google Dabengwa, I think that was the husband's surname, then you can find the case. It's unreported though. In that Dabengwa case, that was one of the first cases where the issue of validity of customary marriages was scrutinized to the core, because it involved two prominent people, and it was very important for the court to get and dwell deeper, not because she was a woman and not because she was in a disadvantaged position, but she even lost, and she got a very hefty court order for taking that matter to court because she knew that it was an engagement. that there was never any negotiations that went to her home. There was never any delegation that went to her home. There was never any celebration. There was never any agreement between her and the husband and the fiance to say now we are getting married in customary law. But it was a pure engagement party with lavish gifts that were given to the family, but nothing else but an engagement. Unfortunately, under those circumstances, the court found in favor of the husband, and rightfully so. If you read the case, then you will realize that, oh, okay, under the circumstances, then this case, the court, if the wife or if the fiance had appealed the matter, she tried, but she still lost. So the court found in favor of the man to say that, but this was just a pure engagement. It had nothing to do with you. Even if you can show the pictures, you were dressed in a decorated traditional dress, but that doesn't necessarily mean that it's a customary marriage. It was just a celebration or engagement celebration, and it ended there.
Oh, okay. So meaning she could have, I'm just thinking out loud here, she could have at least sued for the breach of promise if the delictual elements, all of them are met, because surely I'm just thinking that instead
Yes.
of, yes, she could have
Should have
sued for the
been
breach of
that should have
promise.
been a better option, maybe. Now you're thinking out loud. I like your thinking. Like your thinking. I said I'm gonna take Connie and then I'm gonna proceed because we still have quite a lot to deal with under customary marriages. Can I proceed?
Yes, please.
Yes,
Yes,
there's
can we
something
please
very
move on?
as well. There is something very, very important as well in terms of the recognition of customary marriages act that I would like for you to take notice of. On page 6, where it says Section 7(6) of the Recognition of Customary Marriages Act provides that a husband in a customary marriage who wishes to enter into further customary marriage with another woman must make an application to court to prove a written contract which will regulate the future matrimonial property system of his marriage. The court must, in a case of marriage which is in community of property or which is subject to accrual system, terminate the said system and effect the division of the joint estate according to the proprietary regime and ensure that equitable distribution is of the property. What simply means here is that if you are married in terms of, I think there's a mistake here. It was supposed to say if you are married in civil marriage, which is ensuring that both parties are going to get division in case of death or in case of divorce. There's going to be division of the joint estate. That's where the question that came in that said that if I'm married in civil marriage and I want to marry a wife in customary marriage, what should happen in order to ensure that they get an equitable value of the assets? You must do that court application, and you must make that application to court so that you cover all these wives to ensure that they are covered by the patrimonial or the matrimonial, sorry, the it's patrimonial is the patrimonial regime of the said marriage that you would have entered into, meaning that they must get equal share. If you get that court order that says, okay, in as much as you're married in civil marriage, we're giving you permission to marry a wife in customary marriage. Make sure, therefore, that the contract that you have between amongst these wives, they all going to be benefiting equally from the estate. Not none of them, whether you were married to them in community, out of community, or with or without accrual, that must change to in community in order to make sure that all the wives are in agreement, all the wives are going to get an equal share into the estate in case of death or in case of a divorce. I don't know if you understand that.
Yes, yes, we do.
You understand that?
Yes.
I think just for the sake of time, it will be very prudent for you to go through these cases that are highlighted in the study material, because they give you different scenarios and they help you understand the application of these different marital regimes, how it applies in case of if it's now a civil and then you want to take a customary wife, or but then the issue is if you're married in customary marriage, and then it says that you can marry a wife in civil marriage, but you must also make sure that you protect their interests in the whole customary regime that you want to enter into. So it says that no spouse in a marriage entered into under the Marriage Act or the civil marriage may during such marriage enter into another marriage, which is another civil or customary marriage. So unless if obviously you apply for that court order that gives the husband to say, okay, now I'm married in civil law, but I want to marry another wife in customary law. And another thing is that you can't marry a wife in civil law and want to marry another wife in civil law. That doesn't happen. We don't have such provision in our law. It must also be noted that this situation is only applicable to all customary unions entered into after the 15th of November 2000. So when the Recognition of Customary Marriages Act came into operation, because before the said date, spouses in customary union were not regarded as being legally married to one another. So that's what I said, that remember when we started, the whole thing started before the Recognition of Customary Marriages Act came into play. All customary marriages that were entered into by African people were considered to be out of community of property, and a wife was considered to be a perpetual minor. But that's why you found in the olden days, our grandmothers, our parents, they entered into customary marriage and went to Home Affairs to sign. So I think that's where the whole confusion with registration comes into, because for their marriages to be recognized during the apartheid era and before the coming into effect of the Recognition of Customary Marriages Act, you had to be lobolad and you had to go to the Home Affairs to sign so that you can have a proper civil marriage in place, which will be recognized as a marriage in community of property. The grandmothers, they suffered a lot because they were married out of community. If you are married, you were lobolad in 1948, and it was way before this act came into place, and your husband dies or you divorce, then you walk away with nothing because of you were regarded as a perpetual minor, and the husband was regarded to have powers over you and take over all the assets that you amassed during your marriage. Any other questions when it comes to that? Can I proceed?
Please proceed.
Thank you
We've
very
been
much.
discussing this for
Yes,
an hour
please.
now.
Pardon?
Yes.
Secure, you've got your hand up.
Yes, ma'am. Good afternoon. Good evening.
Mm.
Yes, I have a question regarding the registration of customary marriage. I've read somewhere that any interested party can get that marriage to be registered. So actually, when you're about to register that customary marriage, what are the requirements that you must present at that Home Affairs, to put it like that?
The requirements that you must present the marriage must meet all the three requirements, which is the parties must be 18 and above. Number two, they must have consented to marry in terms of customary law. Number three, there must have been negotiation, celebration, and all of that. So if it meets those three requirements and you've got witnesses to that effect, you can go to the Home Affairs and register that marriage. But again, non-registration does not nullify the marriage. The marriage will still be valid despite being registered.
All right, sorry, ma'am, just to rephrase it, I actually meant that letter of lobola. What must it be as? Maybe you have to present that letter, which has the names of the parties and the people that witness it there, or it must be together, myself as a party involved in that marriage and my spouse that to be present in that Home Affairs. What?
Both of you have to be present. Both of you have to be present, and you must present that letter to the marriage officer. You make an appointment, and then they register your customary marriage, and then you have your marriage certificate, which says that marriage in terms of customary law.
So the delegates that witnessed that contract should not be there as well.
No, you can bring the delegates. Remember, in a marriage, even if it's a civil marriage, you still need witnesses. So you can have delegates, or you can have whoever you choose to have as your witnesses.
All right, thank you, ma'am.
But the norm has been for those that register, they use the delegates to be witnesses.
Hi, ma'am.
Ma'am, with all due respect, can we move on? I mean, people can address the details and the specifics in another forum. I don't think this is the forum to be asking such specific questions. We've been on this for an hour. This
Hi,
is
ma'am.
really not fair, guys. It's really not fair.
Hi, ma'am. I just want to ask something about
Yes.
Islamic marriages. What's the current Islamic marriages? What's the current status in terms of
I
recognition?
will get into that. Just give
Oh,
me
you'll
a
get into that. Thanks.
get into that.
Hi, ma'am. Hi, ma'am. Before you move on, I'm sorry, but can you please be patient with us, especially our fellow, candidates, because I think some of us we really want to ask questions, because this is the platform where we ask questions. So if you feel a question is not, important to you, but that is for you, not for us. So can you please be
Yeah,
patient
but
with each other? We understand that we have
must
to
remember.
cover much ground. I'm still talking, sir.
Sorry,
So
can I interject? Can I interject?
We are in customary all now, guys. There's lots of marriage.
Yes, we are still going to deal with other marriages. Can I proceed? Thank you. Sorry, guys. Let me just switch on my lights. Give me 2 seconds. Okay. To be quite honest with you, customary marriage is dealt with in extensively, even in your notes. So it's not right now is the issue that is burning in court. So I understand when the questions are coming, but let's try to keep them as short as well, so that we can give others a chance. Okay, I am proceeding now. I would like to point out another issue while on the Recognition of Customary Marriages Act, which is very important. Your Section 6. Section 6 of the Recognition of Customary Marriages Act provides that a wife in a customary marriage has, on the basis of equality with her husband and subject to matrimonial property system governing the marriage, full status and capacity, which means that in terms of Section 6, it recognizes both husband and wife to be equal partners in a customary marriage. But now, I'm sorry, Section 7A of the same Act states that propriety consequences of a customary marriage entered into before the commencement of the Act. Those are the marriages that were entered into from the 14th of December 2000, going that side, which we refer to as old marriages, are still governed by customary law. What that simply means, it means that those marriages that were entered into before they were coming into the
You're struggling to hear. Zelda Mampuro, please mute your mic.
Yes, please. Thank you very much. Can you hear now?
Yes,
Can
you
you hear me
can.
now? I was dealing with Section 6. Section 6 gives equal opportunities to both husband and wife in customary marriages. However, Section 7.1, which deals with the marriages, we call them the old customary marriages that came before, it still says that those marriages will be dealt with in terms of customary law, which means that those spouses that were married before that time, at the time of the coming into effect of that act, those marriages will still be considered as out of community of property. And we come to Section 7.2. Section 7.2 of the Recognition of Customary Marriages Act sought to regulate the post-act marriages, which is marriages that came after the 15th of November 2000, which we call marriages, as being in community of property unless agreed otherwise in terms of an ANC. So that is what I was basically saying, to say that when the Act came into effect before its amendment in 2021, it still refers to those old marriages as out of community of property, but those that entered into after the 15th of November to be in community of property, which is unfair in a way. Then I would like for you to go and read the rest of page 8, wherein the propriety consequences are dealt with by Pinar in an article where he explains how this empowers women who are married in terms of the old law, and how it's also against the constitution, which recognizes uh, equality in terms of section 9.2. So there's been court cases, there's two major court cases that deals with this whole issue of section 7.1 and section 7.2. So you will look at the Gumede case, which deals with the unfairness of section 7.1 in marriages that were entered into before the coming into effect of this act. And then you look at the Ramuobi case, which deals with polygamous marriages that were entered into by the parties after before the act came into effect, to say that those people that are married in terms of this act, they should also be considered when it comes to division of the joint estate. They should not be let out just because they got married into these marriages before the coming into effect of the Recognition of Customary Marriages Act, primarily saying that it should actually apply retrospectively from the old marriages and not disadvantage those people, because we are all equal before the eyes of the law. I think if you can go into those two important cases, the Ramobi case and the Gumede case, that's where you'll understand the application and how the courts distinguish between the benefits on people that were married before the act came into place and the benefits of the people that are married in terms of customary law but in a polygamous relationship. I will proceed on that. Please note those cases. They are very, very important to take note of. Now, we come to the dissolution of customary marriages. How do we dissolve these marriages? In our culture, they will always tell you, we still have it. We still have it, unfortunately, primitively. So people still believe that if you are married in terms of customary law, you just have to go and get nothing. But the law has changed. Customary marriages as well can be dissolved by way of divorce, whether or not the marriage has been registered, as long as the parties can prove the existence of a marriage during the divorce or while they are proceeding or in the process of divorce. If they can prove to the court that there was an existence of a marriage that met all the requirements of a valid customary marriage, therefore that marriage can be subjected to a divorce process, and parties can divorce and they can divide the estate whichever way it goes, but there has to be dissolution by divorce. Am I clear there? Are we still together?
Yes.
Yes,
Together, ma'am.
Funda, you've got your hand up.
Yeah, I just want to ask. I'm a bit curious. I get the theoretical aspect of what we're discussing, but I would like personally to know your experience of what in practice are those challenges when it comes to customary marriage. I mean, the do's and the don'ts, and the predominant factors which presents, problems in this type of marriage. So, in your experience, maybe briefly, Ms. Baloyi, maybe you can tell us what to look out for and what normally are the challenges with this type of a marriage.
The challenge usually comes when there's unpleasantries. Parties don't longer see to eye. And challenges always present themselves when it comes to the third requirement. I think I've explained the Lex 40 principle of where there is a conflict of law. In case of conflicting cultures, what happens? That is the major challenge when it comes to the recognition of customary marriages or where there is dispute in customary marriages. That's why you find that there's different cited cases that deals with that purely that very same requirement, because it's the one that brings about problems. But the wife, in my culture, this is how it's done, and the husband will be like, but in my culture, this is how it's done. For the marriage to be recognized, you need to do this. I gave an example of the Ndebele marriage that I was talking about, and they were both Ndebeles, but the other one was Ndebele Yamgomani, the other one was Ndebele Wamatlang, was Kosana. So they do things differently. Then the court had to determine which is the applicable law and whether or not that marriage met the requirements in terms of both the cultures. And the court found that the marriage did not meet the third requirement, which is the celebration, the negotiation, and all of that in terms of both cultures, and it kicked it out. So you must be in the lookout, especially for the third requirement, because initially we know that parties would agree to enter into a customary marriage. They would both be majors at the time, but then the issue that comes in, and even the example that I gave of an engagement party where the wife thought it was a celebration of a customary marriage. So that's where we get a lot of challenges when it comes to determining whether or not a marriage is valid or not. The case here, HP as well, the third requirement was a problem. They said that no, it's not a valid customary marriage because the wife was never delivered. The court proved, the applicant proved that, but I was presented as a wife. I was taken to the husband's place. Therefore, the court said, but this requirement took place. And what do you mean that this is not a valid customary marriage? And the Supreme Court of Appeal ruled in favor of Ms. Singani. So those are the kind of issues that you must look out for in practice. You must not just take things as they come on face value to say you've met the three requirements. You must probe the requirements. What does it say in this culture? What does it say in this culture? Have both cultures met, their minds met to meet to say we are coming together in our different cultures to make these people get married and to recognize them as husband and wife? I hope I've answered your question. Chula Sizwe?
Thank you, ma'am. I'm answered.
Yes, good evening. Yeah, no, I've heard that this customer marriage can be dissolved in court. So, what would be the procedure or the application? Because I officially didn't know that it can be dissolved in court. So, how do you go about if one wants to dissolve in court?
I will give you an example. There's one magistrate in the regional court in Pretoria. If you bring the Lobola letter that will highlight the three requirements, he will use that as a marriage certificate to say that, because remember when you file for a divorce, you must issue summons and you must state in your summons, you must prove that you are the plaintiff, the husband is the defendant, if he's the defendant, then the jurisdiction of the court, you must also prove that the marriage exists. And in that instance, when it comes to customary marriages, if it's registered, then you will cite that it is registered in terms of whatever which provision, and then you attach the marriage certificate. If there is no marriage certificate that you have, and the marriage was not registered, then you must prove to the court there is a citation that you must put in as a paragraph that will prove that there is an existing valid marriage in terms of customary law. If you can be able to convince the court and prove your marriage, then you can be divorced. But if you can't prove the marriage to the court, then the court cannot proceed and grant you a divorce on the basis of a customary marriage. Are you answered, Kila Caesar?
Yes, definitely. Thank you.
Thank you very much. Okay, that concludes our discussion today for customary marriages. We now move to civil unions. Civil unions are what we call same-sex marriages in simple languages. They are concluded in terms of the Civil Union Act of 17 of 2006. The act applies to same-sex marriages or heterosexual couples. Such couples may enter into a marriage or civil partnership depending on whatever collective noun they want to use for that, but it is recognized in South Africa as a valid marriage in terms of the constitution. And even those civil unions, they can be dissolved by a divorce, though the what do you call it, the Civil Union Act, it does not deal with the dissolution of marriage per se. Hence the use, it was decided in one of the cases that the use of the divorce act would be the most suitable way to dissolve such marriages. So they are also capable of being dissolved via a divorce. So those are the simple things that you can deal with in terms of civil union. So it's not a complicated system. It's more like your civil system, which is non-complicated and straightforward. A dissolution of it, it's on the basis of irretrievable breakdown or whatever reasons that could have been advanced before the court. And then Hindu marriages, there was a question that came, I think it was on Muslim marriages.
Sorry, Ms. Baloyi.
Yes.
Yeah.
Can you raise your hand first so that I can recognize you?
Okay, sorry, I will do that next time. Yes. So, yes, I just want to ask when it comes to civil union. You sometimes get a case where the pastor who needs to officiate, or whoever the counselor may be, the marriage officiator, is quite reluctant to do that because of some religious reservations. So understanding that may be discriminatory, and such a party who maybe perhaps would have loved that pastor to officiate the marriage doesn't come to the fore. So is the pastor then in breach of whoever's rights in part or whatever partner in that civil union? Because I understand that that is a question of a balancing of rights, as much as they are entitled to that kind of a setting or a setup of a marriage. The pastor also has a right to his religious freedom. So I just want to ask, when it comes to the officiation part, it might not be part of this, lecture, but is the pastor does the pastor have remedy for that, to say, no, I won't be able to officiate, I won't be able to marry you, find someone else?
Okay, Section 6 of the Civil Union Act does provide for that. It says no marriage officer who belongs to a religious denomination or organization can be compelled to solemnize a same-sex civil union. That is in terms of Section 6. So they will have to find someone who will be willing to officiate that type of marriage. But otherwise, you cannot force a marriage officer who belongs to a particular religious denomination to solemnize such marriage.
Yes, ma'am, I have my hand up.
Yes, Zandile?
Yes, I think you were referring to the Hindu marriages, but I actually asked a question about Islamic marriages.
Yeah, no, I'm still going to get to that.
Oh, you're still going to get there. Okay, thanks.
Yes, I'm still going to get there. Okay, I think we are done with civil union. It's not a lot of content that is being presented or that has reached our courts in terms of civil union. So it's easy as that. Now, Hindu marriages, the status of Hindu marriages is that there's nothing, there's no any law or promulgated statute or any given law that has been in place yet to deal with Hindu marriages. It's still with the South African Law Reform Commission, and they have not come up with how to deal with Hindu marriages. So I would take it that if people enter into Hindu marriages, it will also be advisable to go and enter into a civil marriage like they used to do it in the olden days with customary marriages, in order for the marriage to be recognized as a valid marriage in South Africa. So in terms of Muslim marriages has since been subject of ongoing investigation and discussion by the South African Law Reform Commission. However, Muslim couples who choose to marry according to Islamic law can only be afforded the protection of a South African legal system as it pertains to spouses if they, in addition, to register as a civil marriage. However, there is a constitutional court matter which was decided in June 2022. Must go and have a look at the full judgment, where the court decided that it is only prudent to deem the Islamic marriages the same way as it dealt with customary marriages. Therefore, there is a recognition of customary of Muslim marriages that is in place at the moment. The case that you will find it on page 12 of your notes. It's Women's League versus the President, Women's League Center Trust versus the President of South Africa. This judgment recognizes the validity of Muslim marriages and protects the rights of people who marry according to Muslim rights, especially women and children. So there has been headways that has been made when it comes to Muslim marriages. Though the Constitutional Court found that in terms of divorce, the Divorce Act will have to be applicable as well in this instance. And yeah, that is basically what has been going on in terms of the Muslim marriages. They have now been recognized in terms of that particular act, that particular case, which was decided last year in June. Does that answer your question, Zandi? Zandi, you have your hand up. Sifunda?
Yeah, I do hear you, Ms. Baloyi, on your response to Zandi regarding South African legislation or any codified law on the Hindu and Muslim marriage. But I'm just a bit concerned because the section in our constitution that says the court may perhaps look at international law, if more especially there is no legislative authority on the subject matter at hand. For an example, if we don't have any legal framework to sort of govern these marriages, the question would be, why not look internationally at how these laws, how these marriage institutions are governed, and maybe try perhaps to customize that into our context as a state. So seeing that there is little to no effort from the court, I want just to ask, has there been any developments towards such a regard?
I don't think there hasn't been any efforts from the court for the mere fact that there is a decision that was decided in June 2022, but that it lies with the legislature to say what legislation can we bring into place if it can bring about the Recognition of Customary Marriages Act, which applies to, as they call us, indigenous people. Why don't they have something like Recognition of Muslim Act, which will regulate, So it's still under construction, if I may put it, that they are still working on maybe coming up with a legislation that will properly regulate the Muslim marriages, just like it regulates the African cultural marriages. I mean, Section 30 and Section 31 of the Constitution is very clear when it comes to the enjoyment of culture and cultural beliefs. So I should think that should be the premise without even going outside and look into international law, but we look into our own constitution. What does it say about cultural practices? It's very clear in Section 30 and 31. So it's just the slow pace that has been moving. It's been moving in really snail pace. So we're just hoping that the makers of the law are listening, because people are writing about it. There's articles and articles of how the law deals with Islamic marriages. So we're just hoping that it will come to the fore. It's not up to you and me to decide, but we know we can be the voices of reason to say when we get cases like that, can we take them forward and fight for those people's rights? Paco? Okay. I think there's Omaya. Omaya, you have your hand up. Going once, twice, gone. Mama Tabo.
Hi, Spongile. So I
Hi.
just wanted to add on what the previous gentleman said about using international law to develop statutes rather, or the legislature in terms of Islamic law. I just wanted to add that if I remember correctly, in terms of the Maintenance of Surviving Spouses Islamic laws, for purposes of that act specifically, surviving Islamic spouses are recognized as true and proper spouses, even though the marriage itself that they entered into is not recognized in terms of any law in South Africa.
No,
So
but
they
it is recognized now. If you go and read that case, the Women's League Center Trust, it is recognized. So that's why you find that statutes like that, they now recognize the spouses in Sharia law as spouses
Yes.
to claim maintenance in terms of the surviving spouse legislation.
Okay, all right, thank you.
Okay, thank you. Zandile, you still have your hand up.
It's an old hand. Let me just put it down. Thank you.
Okay, thank you. Okay, thank you very much. I don't know, can we take like a 5 minutes break, just get water, and then we can come back and now come and deal with the systems of marriages that we have, and then see how far we
Yes,
go with that. Can we come back at, oh, you need 10 minutes. Come back at
10
25
minutes,
past
please.
10 minutes, ne? Okay.
10 minutes.
All
10
right. Thank
minutes.
you.
Guys, we understand we're on a break, but please switch off your mics because there's background. I think it's Ignatius or somebody else. So please switch off your mics, please.
Okay. Yeah.
Jay Bonokwane, please switch off your mic.
Welcome back, everyone. I see there's a hand. Come on, hello.
Welcome back.
Can you please mute, switch off your video? Kilton? Kilton,
Yes, ma'am. You know, I'm
can you
trying to
please
switch
switch off
it
your
off.
video?
Yes, I'm struggling to switch it off. This button here is not properly doing.
It's going to
Trying to
give us
switch
a
it off.
problem. Maybe leave, then rejoin.
Yeah, I'll do that. Thanks. I'm sorry about this.
Thank you. Mabatu, you have your hand up. Is it an historic hand, Mabatu? Okay, then I will just leave it there. Okay, ladies and gentlemen, as we continue now, we're going to be dealing with the systems available in our marriage system. And when we talk about systems, we talk about your marriages in community, out of community, and with or without accrual. The first community system, which is mostly popular or becoming unpopular, is the marriage in community of property. This is regulated by Section 14 to Section 20 of the Matrimonial Property Act 88 of 1984. According to this provisions, where people are married in community of property, it means the one comes with the estate and they come with the estate, and whatever they amass during the marriage, it becomes one. So in cases of death, for instance, if the party dies without leaving any children, then the surviving spouse will have to inherit everything. In case of divorce, the other spouse, the estate will be divided into 50% equally. Each party will have to get what is equitable between the two of them. But there is a disadvantage about this type of marital regime. I think we all know that when you're married in community of property and you've got businesses, for instance, that can become a disadvantage because your estate can be affected by that. Can you mute yourself, please? Sifunda?
Yes,
Sifunda?
why? Because they were following miracles. They were not after the gospel of Christ.
Sifunda? Can you please mute yourself? Thank you. I lost track. Okay, I was just talking about the disadvantages of marriage in community of property. Is that in case of insolvency, it affects the joint estate. In case of death, it affects the joint estate. In case of being blacklisted, it affects the joint estate. If the one party or the one spouse is blacklisted, it also affects the profile of the other one. So, but other than that, people still marry in community of property. You must also know that all marriages under customary marriages that are not excluded by an ANC are also marriages in community of property. Any questions under the in community of property regime? No questions. Thank you very much. Then we have the marriages out of community of property with accrual. This is where the parties, when they enter into, it's more like they say it's a marriage in community of property in disguise. So what happens here is that whatever you bring into the marriage belongs to you, but whatever you amass during the marriage, then you can divide that according, it can be redistributed according to your contribution into the joint estate. So if, for instance, you had a startup value of both 50%, 50%, then you enter into a marriage, your 50% still belongs to you as a husband, the 50% still belongs to you as a wife. Then during the marriage, the husband contributes 60% into the joint estate, and the wife contributes 40% into the estate. Then you will get what you distributed, or what you, sorry, you will receive what you contributed into the marriage. It's not an issue of you're going to be divided into 50-50. It depends on the commencement value and the end value, whether the end value is more than the commencement value or the commencement value is less than the end value. There is a calculation that is done there in terms of the actual system. I think you were well taught at when you're doing family law how to calculate the actual system. That is the most suitable if you've got assets that you have amassed and you want to enter into a marriage out of community of property. You can decide, if you decide you want to still have that joint doing of things, then you can enter into a marriage out of community of property with accrual system. Then the marriage of that excludes the accrual system is marriage out of community of property, which is completely out. So what you get is what you come with is what you go out with. So there is no contribution towards the joint estate. But there is one thing that I've noticed with parties that enter into marriages out of community of property. They don't keep proper records of what they do, of what they contributed during the marriage. And when it comes to a divorce, you find someone saying, yes, we were married out of community of property, but then the other party still comes and says, I want 50% of your pension, I want 50% of it, forgetting that they have already entered into a contract that excludes completely any communal estates that they can share after the dissolution of the marriage or upon death. So it's things that people sometimes you need to explain to clients that come and want to register an actual system or complete marriage out of community of property, what the implications are and what the benefits are. Explain in full so that they understand, so that when they register that, then they know what they are getting themselves into. But it also happens that sometimes you find that people had the intention to enter into marriage out of community of property, but they make that very same mistake of paying lobola and finishing the whole lobola and customary marriage part, and then they want to come out later and register an ANC. That will not be a valid process to follow, because you need to register the ANC before you enter into a customary marriage. That will also apply into now the Muslim marriages, because they've been recognized. So that is basically what is the law surrounding the systems of matrimonial systems that we have in the country. And Mabatu, you have a hand up. Mabatu? A question was raised by one of you gentlemen, ladies, regarding.
Sorry, I have a question.
Okay.
Regarding marriage out of community of property with accrual. So you refer to it as marriage, customary marriage in disguise. I mean, not customary marriage, sorry, marriage in community of property in disguise. When you're married out of community of property with without with the accrual system in place, does that affect, for instance, if one estate has debts, does the accrual system come into play there?
It does.
Okay. So the amount that's divided using the system of dividing the accrual will then be used to pay off the debts of the other.
Of the other.
Okay. And is that compulsory?
Remember, it's a contract that you've entered into. So it has to be a binding contract in terms of the terms of your contract, the way you put it in your contract. Remember, the accrual contract or the ANC in an accrual system should speak to what needs to happen in case of an end by death or by divorce. But must also be make sure that it's not vague, because if it's vague at all and it doesn't necessarily say what needs to happen, then the court might not even consider that.
Okay, okay. Thank you.
So it should speak to your wishes. What is it that you wish to see happening at the dissolution or at the end of the marriage, either by death or by divorce?
Okay. All right. Thank you.
All right. Sharon, you've got your hand up.
Yes, that was me. I was asking the question.
Okay.
Yeah.
Prince?
Hello.
Hello. Prince, you've got your
Yes.
hand up.
Yes, ma'am, I do. I just want to get your personal opinion on this one. There is a case that was decided by the High Court and this in the Constitutional Court now with regard to Section 7.
Which Section 7?
Section 7 of matrimonial property, matrimonial, but yet the one that deals with the question of marriage out of community of property, which says that the parties are no longer allowed to how can I put this thing? But the other party is still prejudiced by if they are in out of community of property, but when they divorce, the other party feel prejudiced. So there's a decided case that is in the Constitutional Court now, where the High Court declared that section invalid. I can't
So
remember.
what is your question?
What is your personal opinion in terms of freedom to contract and the freedom of choice?
Like I was saying to I can't remember the lady that I was just speaking to now, Mawatu, to say that the contract should speak to your intentions, freedom of what did you call it? Freedom of contract, right? Because remember, the contract that you entered into is the contract that should bind you at the end of the marriage. So you are the ones that enters into that contract. And therefore, if you're going to come outside the contract and want to change things, whereas you entered into the very same contract, you should adhere to that contract, because it is a contract in according to your terms. Unless if it is a vague contract wherein you can say to the court, this contract is really, the court can say, this contract is vague, does not speak to either marriage out of community with accrual or without accrual, is just very vague, and therefore the court is going to not consider that. So you should be careful how you word your contract, and hence you need to have a professional who is going to advise you accordingly and explain these matrimonial systems to you, and the advantages and the disadvantages, and what should work in your circumstances. Did I answer your question, Prince?
Let's just carry on. I will try and get the case so that I can speak authoritatively.
Okay, thank you very much. Chula Caesar?
Yes, again. If I can remember well, when we were looking at the type of marriage, community, the out of community of property, it was saying that by default, the first marriage out of property will be with the accrual. Now, following Sharon's question, in terms of insolvents or any getting richer or something, should once, let's say, I am advising a client. Should I advise one client to say, okay, if you're eating the one with the accrual, you can decide both of you. That's if we become one, if one become insolvent, those liabilities, you will be the one who will be liable, not my assets. Is it that correct? Oh.
Are you asking if a person comes and wants to draft a contract? you must advise. How can you advise them in terms of the debts, whether or not they'll be liable for the other one's debts?
Yes, whether one will be liable for the other's debt or each and every person will be liable for each debt.
That's what I'm saying, that your contract should speak to your wishes.
Okay.
If in your contract you are saying, therefore, that we will be liable for each other's debts or we should exclude debts, you should specifically say that.
Okay, all right. Thank you so much.
Okay, thank you. Zanele? Then there's an issue that I want to find out from you. Do you think an ANC can be verbally concluded? Lerato?
Yes, I believe so.
Why do you believe so? What's your authority?
Based on the contracts, there is a valid contract which is concluded verbally. So I believe going on that line.
There is a case. Sorry,
No,
Zanele,
it
you put
has
your
to
hand
be
up.
in writing and it has to be
It has to be
notarized
in
by a
writing.
notary.
I
It
was
needs
going
to
to
be
say it has to be in
notarized.
writing because it's a notarial document.
Yes.
Have you read the case Odendal versus Odendal?
Yeah.
It says unregistered antenuptial contract. The question whether an antenuptial contract may be concluded verbally was answered in the affirmative by the full bench in the case of Odendal versus Odendal. The court held that there was no reason to construe the term antenuptial contract in Section 2 of the Matrimonial Property Act. Consequently, an informal antenuptial contract was binding between the parties in that case. So in that case, the parties verbally agreed to be married out of community of property, but the husband failed to prove that the actual was expressly excluded and it therefore applied. So, the beauty of our court is that if you can prove and you can convince the court on balance of probabilities and you come with a strong argument, anything is possible. I understand the fact that it is a contract which is binding and it has to be validated by a notary public and it has to be registered with a deed. But what happens if people, for instance, thought that they had registered their contract but realized that it was not registered, and all along they've been living that life of a couple married out of community of property, either with accrual or without? Shirley, you've got your hand up.
Yes, I'm just wanting clarity here. If we're saying that a verbal international contract is valid, and as far as the parties themselves are concerned, but not in as far as third parties are concerned, what's happened is, let's say, for instance, our intention was to enter into an international contract, but we didn't. Lobola was done, civil marriage or whatever was done, but we in passing discussed the terms, so we didn't actually enter into an agreement. Earlier on, you said that should we wish to change our marriage regime into one that has an antenuptial contract, we need to follow a higher court process. But then if people claim that we actually did, but just did not register one, how then do we draw the line between what is actually factual and what is not?
That's what I'm saying, that, with matrimonial law, you can never say there's always a gray area when it comes to different cases. But that was just an opening. That case, it was decided. That case, which was decided in 2002, it was decided that the antenuptial contract was verbally acceptable. But if you go on and read of
Sorry,
the
ma'am. Sorry, ma'am. There are people who are.
We can't hear
Mic is on.
Can you please mute yourself, ladies
Please.
and gentlemen, please?
Guys, this is disrespectful, eh?
This
Ma'am,
is very disrespectful.
ma'am, I think you need to close down the questions because we now left with less than an hour, and we
Yes,
haven't even
just
gone
one
up to the.
Let me just go on.
Please,
Okay,
guys, let us reserve.
the
Can we
unregistered
reserve the questions because we're not going to finish this?
Yes. Can you also mute? Please mute yourself, please. Zanele, can you mute? Precious, can you please mute yourself? Precious? Thank you. Okay, the question that was raised, I think I've dealt with that case. And then you've got another case in ex parte Spinoza and another. The court held that it is clear that in terms of Section 86 of the Act, an anti-neutral contract not registered within time mentioned in Section 87 is of no force or effect against any person who is not a party thereto. An anti-neutral contract which has not been so registered is valid and effective as between the parties thereto. Indeed, even a valid anti-neutral contract, if properly proved, will have such validity. That was my point. But it's up to the person how you prove before the court that this anti-neutral contract was not registered because of this. If you've got cases that have been decided wherein the court has agreed to say we accept valid ANC, then it means there is room for that. But we are not saying don't register your anti-neutral contract. We always say register your anti-neutral contract, but it so happens that you've been living as if you're out of communion and marriage, out of community of property, yet your anti-neutral contract was not registered. If you can prove validly before the court that indeed you've been living like that, then who's that? Can you please mute yourselves, please, gentlemen and ladies? Then there is another case in Honey versus Honey. The court stated that it must be kept in mind that the term anti-neutral contract is not a synonym with the term duly registered anti-neutral contract. An anti-neutral contract is valid between the parties inter partes, regulates their matrimonial property system even if it's not registered. So these are the cases wherein it was held that even if an ANC is not registered, or as they put it, as duly registered anti-neutral contract, it can be acceptable in a court of law where it's properly proven. So now we have to move along. It's just issues of practice where they give examples of the power of attorney, what you do with the notary, how the notary registers the ANC where it is registered. I think you can go and read that on your own. It's not technical at all. It's just straightforward, showing you how it's done. And then we can move along and deal with the. Okay, they also say that you must be mindful of anti-neutral contracts that are vague and incoherent, which means you sign, you enter into an ANC, but the intention is not clear whether it's out of community with accrual, in community, sorry, out of community without accrual, or the terms are just vague and the notary did not even pick it up that the terms are very vague, and you proceed with that. And when it comes to state of divorces or dissolution or in case of death, then it's very difficult to interpret such an ANC. Then the courts are really cautioning people, because there is a case wherein there was such a conflict where the ANC was very inconsistent and incoherent, and it was regarded as void ab initio, from which means it was regarded as invalid because it never really interpreted what was the intention of the parties when they entered into the whole anti-neutral contract. I hope we understand each other on that one. Another important thing that I think we should deal with is where parties plan to marry out of community of property with or without accrual, but the notarial contract to that effect is not signed or timeously registered. It is stated that in such a case, the High Court may be approached in terms of Section 88 of the Deeds Registry by a means of a joint ex parte application to grant condonation for the late signing or registration of an ANC. So if you are late with the registration or time has passed where you are supposed to register, because remember, once you've entered into that contract, you sign the contract, what they normally do, the notaries, they've got like a standard form where you complete it as the parties, all the details that you enter into, and then you send it back to them. Then you await registration. So if it is delayed during that period where you send it back, and then maybe they say you must send it back within 30 days or within 3 months, and you fail to do that, then if you decide to want to proceed with entering into that ANC, then you need to bring that application, a joint ex parte application, before the court for condonation of late signing or late registration of an antemutual contract. I think that's a very important factor to take into account, because it might happen that it comes to you as a practitioner that a person is you now a notary and you've given them the standard form to complete, they bring it late, and it's already time has lapsed where they're supposed to have rendered it or to have tendered it in. Then you can advise them to proceed and apply before the court for the court to grant them that condonation. Now, another important factor that I think you should take into account is when you want to change from one matrimonial system to the other. This is very, very important, and it's something that is very technical. It is regulated by Section 21 of the Matrimonial Property Act. In terms of the section, the husband and a wife, irrespective of when and how they were married, can jointly apply to the court for leave to change their matrimonial property system. The court will only grant that application on order on the following reasons: where there are sound reasons for the proposed change, that all the creditors are given sufficient notice of the change or the intention to change the matrimonial regime, and that there is no other person who will be prejudiced by the proposed change. So it's very important to note that you can still change your matrimonial property regime from whichever you have, in community to out to in, whichever way you choose to want to change it, but you must ensure that you meet all the requirements that the court would consider in granting that application, which is the sound reasons, the sufficient notice, and that there is no one who's going to be prejudiced by doing that. And then this is done through an ex parte application, which has to be served to the deeds office. It has to be published in the Government Gazette. The court needs to have jurisdiction at least 2 weeks before hearing of the application. The matter should have been published in the Government Gazette. I think also in the newspaper within the area of jurisdiction of those people who want to convert their matrimonial system from one to the other. So that is very important, that you need to be mindful of all these important factors to filter in when you want to, or you advising someone to change, or you want to change the matrimonial regime. And it also states that Section 21 is now applicable to all the marriages. This also marriages entered into in terms of the recognition of customary marriage. So those spouses that entered into customary marriages before the coming into effect in 2000 of the Recognition of Customary Marriages Act may apply jointly to the High Court or the Family Court to change their matrimonial regime as well. So that also allows them to also have that, freedom of choosing the type of marriage that will suit their livelihood or their lifestyle at this time or the current time. And the cost of that application obviously will be borne by the applicant. And yeah, I think some of these things are just a guideline to show you that what needs to be contained in that affidavit will tell you the parties, the jurisdiction, the marriage, the marriage certificate, the purpose of the application, whether there are children that are involved, the reason for the proposed change, whether where there's a notarial contract, it needs to be attached, and then the creditors, if they've been informed, there has to be that notice that you sent to the creditors, showing that all the creditors that are involved or that are part of this whole system that you want to change have been informed. And also the notice in the government gazette should also be attached, and the notice that goes to the local newspaper should also be attached. And then, yeah, I think your financial position and the fact that there's no one who's going to be prejudiced. If you are the sequestration, you must also illustrate that you are being the sequestration pending, or there's any pending litigation against you. All that information must be contained in that application when you submit it to court to change your matrimonial regime. That is the conclusion in terms of the matrimonial law. Now we come to issues of divorce. The most important thing about divorce that I can tell you is that how you take instructions as an attorney at the first instance. You must try and bring the parties to a form of a settlement. It's very easy to deal with a divorce where parties are willing to meet each other halfway. It's very difficult when parties are pulling apart in a divorce because it always leads to a trial, and a trial in a divorce matter is never pleasant because you don't always get the the result that you desire, but the court will always look into issues of the 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 duration of the marriage. They look into issues of the reasons for the breakdown, the reason for the divorce. So there's a whole lot of issues that are involved when you're dealing with divorce cases. So you must have a proper consultation, a breakdown, and proper instructions in order for you to be able to proceed and execute proper divorce instructions in divorce matters. And especially where parties, as long as parties agree that there is an irretrievable breakdown into the marriage and there is no possibility of reconciliation, then you know that you are dealing with a proper divorce. Because it can happen that the parties want to divorce for convenience sake and there is no proper irretrievable reasons that leads to a irretrievable breakdown of a marriage. Did I hear, Sifunda, did you have a question?
Can I just interrupt? You know, it's very hard for me, I'm not sure about anyone else, to hear you clearly. But when people don't mute themselves, we've got this continual noise and echo coming through. And this is almost a waste of a session because we can't hear. Please, can everyone unmute?
I think you're right, Elura. I think it's the people that are not muting. And we've been saying, please mute. We are adults here. Why can't we just mute ourselves? This is for the benefit of the one dating. It's very important.
Yes. No, it's fine. I think you've covered me.
I did not ask you any question. I was just answering the fact that, you know what, please, let's just give each other a chance.
Okay, no, it's okay, ma'am. But I'm saying my question I wanted to ask you has been addressed in your second presentation of divorce.
Okay.
Thank you.
And who am I speaking to? Is it Funda? Zanele, you have your hand up.
It's a Funda, yes.
Yes, I wanted to ask you what ANC happens if the couple draft down an ANC and maybe one of them passes away or they end up not registering the marriage. Are they regarded as married people, or is it what happens in that sense?
I didn't get the second part.
I was just asking if one of them ends up being passes away, will they be regarded as married, or since they haven't like registered the marriage and at home affairs or with the person who officiates marriages, or like time passes by and they end up not getting married, but they don't destroy the contract, or they don't notify, or what happens?
Dissolution of marriage, sorry, not even dissolution of marriage. If the parties never got to register or sign or anything, there was never any marriage whatsoever in that instance. So it will not be considered as a marriage, unless of course they are going to have they had a customary marriage, but they did not register the ANC or whichever way that you come as a what do you call this, an exception to the general rule to say that you must register an ANC before you enter into a marriage, into a customary marriage, or even a marriage for that matter. Philip, you've got your hand up.
Yes, thank you very much, ma'am. I just want to tell you that I'm using public transport to go home due to catching the session early around 5:30 here at work. So right now I want to leave. Is there anything that you want to tell us to prepare before I leave?
I think you can get the notes from the others because divorce is not long, unlike a matrimonial law. It's not really long and it's straightforward, so you won't be losing a lot.
Okay, should I continue studying my material from the school?
Yes, you can continue with your material, yes.
Okay, thank you very much and have a lovely evening.
Thank you very much. Thank you very much. So I was just saying that the better way in dealing with divorces is to settle, try and have roundtable conferences, bring the parties together, try and mediate where possible, and try to get an amicable settlement agreement which will be suitable for both parties. Very important to make sure that parties understand what is entailed by a settlement agreement and that it speaks to their intentions. Both of them, the same language, they must speak the same language. Otherwise, you will have a situation where you'll be sitting with a variation of a decree of divorce because the one party did not understand what exactly was entailed during the signing of the settlement agreement. So it's very important. And also the issue of speaker, which has now come into place. When you take instructions, you need to have those speaker documents because when we do our registration as well as attorneys and you apply for a fidelity fund certificate, they always ask you about the speaker affiliation and all of that. So it's important that you bring that out when you're consulting with your clients. Don't forget that. Discuss the issue of cost. How is it going to work? It's better for a client to come and pay you 20,000 rands. You deal with the case rather than you have a client that comes and say, I have 2,000 rands. I want you to help me with a divorce, and you can see that this divorce is definitely going to be opposed. It's going to be an opposed divorce, and then you're sitting with issues of cost and you have disputes over cost. So it's very, very important that your fee structure is properly discussed from the word go with the client so that they understand what they're getting themselves into instead of just, discussing issues and not discuss issues of money because that can bring you a whole lot of problems as you go about. Now, what is very important in divorce matters, other than where you couldn't settle, when you do your divorce summons, what is very important is the structure of your divorce. Firstly, you must cite who the plaintiff is, where they stay, where they work, what they do. Number three, you must cite who the defendant is and exactly the same particulars, whether they're working, whether they're staying, I'm sorry, where they're staying, where they're working. If they're working, if they're not working, you state they're not working. Number three, the jurisdiction of the court is very, very important. That there has to be jurisdiction, the court that you go, the forum in which you're going to bring the divorce before, it must have jurisdiction either by way of resident or working address of either the plaintiff or the defendant. So the defendant or the plaintiff must either be resident or permanently resident within the area of the court's jurisdiction or working there within the court's area of jurisdiction. And another thing which is very important is the grounds for divorce. Every divorce must be based on grounds of irretrievable breakdown. If the parties have not lived together as husband and wife for a continuous period of over 1 year, at least 1 year, sorry, immediately prior to the date of the divorce action, that is one other reason which is very important that the court will have to look at. And if there's any adulterous relationship that one of the parties find themselves in, that can be used as one of the major reasons for divorce. And the irretrievable breakdown of the marriage is one important factor that the court will have to look into. And yes, then a court will grant a divorce decree on those grounds that it has satisfied itself that the marriage has irretrievably broken down and there is no possible way of the parties coming back together. And there is also a situation wherein maybe you are divorcing due to mental illness or continuous unconsciousness of your partner. That also happens, that a partner, is mentally ill and the other partner doesn't want to continue with the marriage anymore. In case of mental illness, the defendant must have been admitted in terms of the Mental Health Act as a patient to an institution in terms of a reception order for a period of at least 2 years. In any case, two psychiatrists, one appointed by the court, must specify to the court that there is no reasonable prospect that the person will be cured of the mental illness. And in case of unconscious person, the court will only grant an order if the defendant was unconscious for a continuous period of at least 6 months immediately prior to the conclusion of the action or of the divorce, or also after hearing evidence of two medical practitioners, of whom one shall be a neurologist or a neurosurgeon appointed by the court, who must declare that there is no reasonable prospect that the defendant will regain consciousness. I think those are the things that we hardly find in practice, but they are there just in case you need them or a question comes, then you should be able to answer the question that it is possible to divorce someone based on mental illness and based on unconsciousness. I have dealt with the issue of jurisdiction, the importance that the court must have jurisdiction. If the court doesn't have jurisdiction, the other party can raise a special plea to say the court doesn't have jurisdiction, and the matter will be struck off the roll, and then that will be the end of it. You will have to reinstate the matter in a proper forum which has jurisdiction over the both parties. And jurisdiction as well, the regional courts have been granted the same statuses as the high court in terms of divorce matters. So they can hear cases relating to nullifying of a marriage or a civil union or any question that may arise from that. They can determine cases relating to divorce and questions arising from divorces. They can also deal with issues of recognition of customary marriages act. They can also deal with variation of divorce court orders, but not maintenance issues, but they can also deal with issues of adoption. So when it comes to matrimonial issues, the regional courts have exactly the same status as the high court. So it depends, or it can also depend maybe on the value of the oh no, it doesn't apply. Sorry, the what do you call it? The financial value in this instance doesn't apply. So it's a choice whether you want to take the matter to the high court or you want to take the matter to the regional court. With the high court, obviously for the attorney, it's on a higher scale, and if the estate is bigger, it's on a higher scale. But it doesn't necessarily mean that you cannot take it to the regional court. The regional court will still have the same jurisdiction as the high court. And jurisdiction of variation of orders, both the regional court and the high court have jurisdiction to vary its own orders. So the regional court cannot vary a court order that has been granted by the high court. Neither can the high court vary a court order that has been granted by the regional court. So each court has to have the jurisdiction to vary its own order. By variation is where, for instance, there is a clause in the summons that says that the one party has an interest in the pension fund of the other party, but you find that the name of the pension fund or the pension number is not stated, then it is in terms of the Section 7 of the Divorce Act, you have to specifically cite what is the pension number, what is the pension name. If that is not cited, then you can bring not you call it a variation application to change, just to vary, not to change, but just to vary and make sure that the correct details of the pension fund, for instance, are properly stipulated so that it's not rejected when it gets to the other party's pension fund, because you have as spouses you have a right to claim pension fund or provident fund from each other, or you can waive that right depending on what the parties agree on during their divorce proceedings. So in divorces as well, there is what we call, it's an Annexure A. So in cases of a divorce where there is children, there is a form which is compulsory that needs to be completed by the person who's instituting the divorce. We call it an Annexure A form. It gives the full details of the minor children, who they are staying with, what ages are they, who is looking after them, and all of that. It's one of the compulsory documents that you have to attach to your summons for divorce where there are minor children involved. And where there is a dispute, for instance, over which parent should have permanent residence, which is what we used to call custody, if which one should have permanent residence or of the minor children, we use what we call an Annexure B form. An Annexure B form is a referral to the family advocate. The Office of the Family Advocate is there to determine which is the best suited parent to look after the children, or for the children to be staying with one of the parents. So they would do an inquiry by looking at that form, looking at the pleadings that are submitted either in a form of summons or a plea and a counterclaim where there is a dispute over who should live with the children. Then they will interview the parents, interview the children, make an assessment, write a report, do a recommendation to say, okay, we recommend that these children are better suited to stay with the father because of 1, 2, 3, and 4 reasons. And then as a result of that, it becomes part of the documents that you will present to court, is to say that there is no longer a dispute when it comes to the minor children because the matter has been referred to the family advocate, and these are the recommendations, and the court will have to abide by the recommendation most of the time that are made by the family advocate. I've never made a situation where a family advocate has made a recommendation in a report and the court rejects that. Probably it is there, it could happen, but I've never had a situation or encountered anything like that, because even when you go to court and you find that on the day of the divorce hearing, there is still a dispute over the issue of the minor children, the court will just dismiss you and say, refer the matter to the family advocate so that they can make a proper inquiry and make a proper recommendation, which the court will abide by those recommendations. Also applicable that as attorneys we should be mindful of is the Children's Act in terms of the divorce. There is specific provisions that are made by the Children's Act which should form part of the summons or the plea and the counterclaim in cases where there's a divorce that involves minor children, which speaks to visitation rights, responsibilities as guardians, as parents, your responsibilities, your duties, and your rights as parents to the minor children. That is very important that you should have that chapter 8. I think it's section 18, I can't remember 18 what, of the Children's Act that deals with how parents should manage or co-parent their children in terms of visitation, in terms where the children will be staying, and in the best interest of the child. So everything that is done within that same submission to court has to be done in the best interest of the minor children. So there are also very important things important role players when it comes to issues of divorces, and making sure that their interests are protected despite the disputes between the parties, but make sure that the children's rights are protected at all times. Yeah, guardianship and rights to care also established by
Excuse me, ma'am.
the court, by the
Excuse
Children's
me,
Act.
ma'am. My hand was raised for some time. I'm not
Can
sure
I
if you
just
can
finish
see
this
me.
one, then I can take questions. Just the last one. Yeah, so it still speaks about guardianship and care, which we used to call custody. That's what I said. It's dealt with in the Divorce Act. It's dealt with in the Children's Act. That should also be covered when you're dealing with issues of divorce where it involves minor children. It's very important that you must outline that, because even when you do your prayers, you must indicate to the court where the minor children should reside with, who should be responsible for what, maintenance, guardianship, care, responsibilities, and duties of the parents should always be highlighted. I will stop there for now and ask for questions.
Yes, ma'am. My question relates to jurisdiction.
Yes.
My understanding, and please correct me if I'm wrong, that jurisdiction is determined by the where the parties are domiciled.
Yes.
Is there any other thing that will determine a jurisdiction of a court? And I will tell you why.
I think where they work as well is also considered under jurisdiction, where they are employed.
I'm asking specifically because I was perusing a combined summons that emanated from the North Gauteng High Court, although both parties were actually domiciled in the jurisdiction of the South Gauteng High Court.
But it says North Gauteng.
Yeah, it said Pretoria, actually Pretoria.
I think that, I don't know if it's a mistake or it's a trick, but if they are both domiciled within the court's jurisdiction, then you would rather use that. But you also have a choice. If they're spending a lot of time at work and it's outside, let's say for instance, in that instance, they are both domiciled within South Gauteng jurisdiction, but they are working within North Gauteng jurisdiction. So you can choose whichever jurisdiction. You have jurisdiction of choice whether to take the work or to take the, because you must cite when when you do your when you present your evidence in court, you will state the parties the above honorable court has jurisdiction because both parties are employed within the court's area of jurisdiction. Or you will say the above honorable court has jurisdiction because both parties are domiciled within the court's area of jurisdiction. So you have a choice. Did I answer your question, Mr. Okay, I see there's a hands from Gamugelo. I'll go according to the.
Yes. Yeah, my question is that on the ex parte applications.
Which one?
The one where the person is either mentally ill or unconscious.
Yeah.
Is there any other party that can defend on behalf of the other party, the one who's unconscious or the one who's mentally ill? The person who can.
No, the law does not make provision for that, because remember, these people are married to each other. There is not that party that they are married to. All the court needs to prove is the requirements that are set out in terms of the Mental Illness Act and the other provisions where the person is unconscious, because there are the two parties in the marriage. So the only third party to make a determination is the doctor that is being assigned by the court and the other doctor who is treating as well. Then the court will, it's not an ex parte application, but it's a divorce that you can use. Those are the grounds that you can use to file for a divorce, other than the irretrievable breakdown of a marriage.
Okay. Thank you.
Thank you very much. Kaifas?
All right, Inkomo, Manan Baloyi, I have, I think, two. One, I noted that you mentioned something about High Court, that the regional court has been given same status as the High Court in matters of divorce. So I have a question with that to say, one, maybe you can assist us with the authority that has provided that such powers. And then two, I would like to check that if the regional court has the same powers as the High Court in such matters, will that include declaring certain parts of the law or legislation unconstitutional? And the reason why I'm saying this is because if you look at, I think, Chapter 8 of the Constitution, it does indicate that powers to declare certain positions of the legislation unconstitutional.
I think you've lost me, or I'm lost, because what I was referring to, I was referring to issues of divorce and matrimonial property issues. For instance, issues of adoption, issues of divorce. Those are the only matters wherein the High Court and the Regional Court have the same status, but not to declare anyone or any provision unconstitutional. That was not what I was saying. What I was saying was I was referring to the issue of jurisdiction, that they have the same exact jurisdiction when it comes to divorces and issues that are ancillary to divorces.
Okay, no, I follow that. The reason why I'm raising this is because sometimes, let's say, for instance, as the divorce occurs, one would have to make reference to the Divorce Act. And maybe if we then say the regional court has same powers, it may be that certain parts of the Divorce Act are perhaps in unconstitutional, as it happened in the case here. Is it Women's Legal Center or whatever? Or does it mean that if there's that issue, then that matter must then be referred to the High Court?
You mean when there's a constitutional dispute that needs to be raised?
Yeah, because
yes.
It's with
Yes,
this.
you are very right.
Oh, okay.
Okay.
Not that.
Then there's Gibson.
Hi, Sibongile. Thank you. My question is more admin related. I want to ask if there's like a contingency plan in order to cater for instances like this, whereby we did not cover half of the work for the given period, like a plan maybe to schedule another lecture or to pre-record and upload on e-leader, or to send slides or something that may assist us in digesting the guide. Thank you.
Okay, thank you very much. I think I will have to arrange that with Miss Gala. I'm not sure if she's still on the forum, but because we've run out of time, as you can see, and well, there is a lot that still needed to be dealt with, but it's issues that are ancillary to matrimonial property law, which I don't mind. I can do a recording or whichever way that will be suitable, and then it will be sent to you. I don't know how you're going to ask questions when it comes to that, but I will be bringing maybe practical examples on issues so that you can understand them. To be quite honest, this was a very limited time. The scope is very huge, and we have to cover the whole scope within 3 hours. So I agree with you. I will arrange with Ms. Gala, and I will see what I can do for you guys.
Okay, no, thank you very much. We would appreciate that. Thank you.
Okay, then there's Paladi. Kiladi. Okay. Kefas. Okay, no. And then there is Sharon.
Hi, yes. My question is more relating to divorce and minor children. Just two things. the annexure A and the annexure B. Obviously, the annexure B has to go to the family advocate for endorsement, right? With
Yes.
regards to the family advocate, does that depend on the jurisdiction? For instance, the family advocate in Pretoria and the family advocate in Joburg, will that be, for example, if I have a divorce summons that is in Joburg, the family advocate that will have to be consulted is the one in Joburg, right?
Yes.
Or can it be either?
No, it can't be either. It has to be within the court's area of jurisdiction. So in
Okay.
every area of jurisdiction, there is a family advocate. For instance, Hammanskraal, I don't know, for some odd reason, still falls under Northwest. Their
Yeah.
family advocate is in Rustenburg,
Okay.
whereas the divorce I had in custody issues I had in Temba, in magistrate court. So it has to be within the court's area of jurisdiction, the family advocate.
All right. Thank you.
All right then. Sobo.
Yes, thank you. I want to know where both parties, the divorce parties, are in agreement. Should they use one attorney or assistant, or each should have their own attorney? Thank you.
Well, it depends on how comfortable they are. If they want to enter into a settlement agreement from the inception of the divorce, then it becomes cheaper for them, and then you would do that for them. But if so, people when they are divorcing, they're not in good terms. So where you find that there is dispute and you might be compromised in terms of your ethics and your somehow you feel that you're going to be compromised, you'd rather have the other one have their own attorney representing them than dealing with both of them because of conflict of interest that you might have. So you want to avoid such things and make sure that both parties are happy at the end of the day. Some of them, they would come to you and say, we want to do a settlement agreement, and then either one of us can be the plaintiff or the defendant. We just want the divorce. Here is what we want. This is our settlement. We want to sign it from the beginning. And then you have them sign the settlement, and then it's done like that.
Okay, thank
Are
you.
you answered, Sabo?
Yes,
Okay,
yes. Thank you.
okay. There's Misali. Misali?
Can you hear me, ma'am? Oh, sorry.
Yes,
Can you hear me?
yes, I can hear
Okay.
you.
I want to ask regarding child maintenance. If you are going to apply for a child maintenance, they say there's a list that people are given, including the work address of the person that you want to claim maintenance from. What if you don't know the work address? Is it possible for the maintenance officer to help you in finding where the person works, or it is your responsibility as the applicant?
It is your responsibility as the applicant to look for a tracing agent. But I know that the maintenance court somehow they help around with such things of tracing people and their workplace. As long as you can give them direction to say, I think they work here, they have those resources to search for people and find them through SARS and other avenues. So I think it will really depend on the type of maintenance officer that you get, but I think they do have the latitude to assist in tracing and tracking people.
Okay, thank you, ma'am.
Thank you very much. Uh, Kamukelo. Kamukelo, you
I don't
have
have
your
a
hand.
question. Sorry, I don't have a question.
You have a question?
No, I don't, sorry.
Oh, okay. Ladies and gentlemen, I don't think I should go into another topic now because the next part that we should be dealing with is parenting plans and caregiving, joint custody, co-parenting, maintenance. Yes, so parent alienation in cases of parents that are not coming to the picture. What is the role of grandparents and same-sex partners when it comes to children? The rights of unmarried fathers, paternity disputes, the family advocate, which we have touched on, the abduction, that is the Hague Convention that we're supposed to deal with, immigration and relocation of parents in cases of divorces, the children's court, the virtual visitation, maintenance, which we have touched a little bit on, uh, children's maintenance, spousal maintenance, how do you go about claiming for that? So basically, that is what is left for us to finish up our syllabus. So I will speak to Ms. Gala, and then once she has given me an indication on what to do, then I can record the remainder of the notes and what is important and what you should note and what you should know. Yeah, because basically what is left is more of the practical component on how divorce is done, issues of forfeiture in marriages, in community of property, where the other party doesn't want to share in, separation issues, universal partnership and cohabitation. Those are the issues that are left for us to deal with, which I also find they are very important to note and know for matrimonial purpose, matrimonial law purposes, because it's a very vast area. I think if they'd given us 5 hours, it would have been done. I would have finished all of the topics. But yeah, thank you very much for the challenging questions, for the interaction, and I hope I managed to help there. I could help. I don't know how the school works. If there's any other questions, I wouldn't mind to answer your questions via email, but I will speak to Ms. Gala again and find out from her. Is there anyone last question? Because we are already time out. Mhlali, you have another hand up, or is it an old hand?
Oh, sorry, ma'am, it's a mistake.
Zanele?
Oh, yes.
Do you have a question, or is it an old hand?
Sorry, I'm asking a question. Is there ever a situation where one party doesn't want to get a divorce? And is there a situation where the court doesn't grant the divorce? Or is there a case where if one party, maybe if there was infidelity in the marriage, wants a divorce, the court automatically will grant the divorce?
Well, once a divorce summons has been issued and reasons have been given, and you choose not to want to divorce or sign for the papers, because remember, service of summons for divorce has to be served personally on on the person. So if, for instance, the sheriff comes to you and say we are serving you with divorce papers and you refuse to sign, it will be a service non, which means there will be no service. But that doesn't stop the person from going and doing a substituted service divorce via the newspaper. Because if you don't want to sign for the divorce summons and you're refusing to receive them, then you're putting the other party in prejudice. Then they can invoke other means to divorce you, which is by newspaper, and that divorce can go through. But at the same time, even if you take the divorce papers but you don't defend them, the divorce will still proceed and be granted in what do you call this, in default, if you don't respond to the summons. So either way, you're gonna get divorced, because there are other means other than issuing of summons directly to you, but they can be served and be published via the newspaper, and you wouldn't even know that that has happened, and then you'll be divorced, and you won't even have the right to fight what's due to you. Did I answer your question, Zanele? Okay. I think those were the hands that were left. Kefas, do you have a question?
Yeah, thank you very much. Just one. I want some clarity, most probably when we were, I think, making an issue about one couple that has had not fulfilled certain customary practices, and the court did not decided to not to consider such a marriage and not as a valid marriage because certain things were not fulfilled. One, I would like you, if possible, you assist in terms of typing the case. And the reason why I'm requesting this is because if you look at the double HP case, you realize that certain customary Tswana practices were not fulfilled, and that's why double H father was contesting that the
But double HP was not Tswana. He was from Maputo.
okay, but yeah, then the essence is to say um, the certain customary marriages or practices were not fulfilled because the father was contesting that if a wife is married in terms of their culture, certain things need to be fulfilled. Now we're sitting with a situation where in the double H PH case, the court did allow them to consider the marriage valid, even though certain things were not fulfilled. While on the other hand, certain things were not fulfilled, and then it appears as you made an argument that the court
Have you
said,
read the full judgment, Kefas?
which one, the double HP case?
Yeah.
Yeah, with the double HP, I'm aware. That's why I'm saying if you
I'm
ask,
asking you, have you read the full judgment of the Supreme Court of Appeal?
yes, with the double HP, I'm aware of what the issues are. But the other one that I'm not aware is the one that you were talking about. So hence,
I said the surname is Dabengwa. I can't write on my chat. I wanted to write it on my chat. It's Dabengwa. Just Google Dabengwa.
okay, all right. No, it's fine. Maybe I'll look at that and maybe try to make a comparison to understand
Yes.
why, because it seems to me that
No, it's
the
not the same thing. That's why I'm telling you that all customary cases are different and that's why they are dealt with differently. You can't use one blanket for all.
okay.
All right. Thank you very much. I think it's time for us to leave now. Thank you so much for your time and thank you so much for listening attentively. You will hear from Miss Gala. She will communicate with you on the way forward and all the best with your exams. And yeah, just take everything as practical as it comes and read mostly the cases because they answer most of the questions. I like how the cases have been outlined to deal with each and every issue that we had to tackle. Thank you very much for a lovely evening. Good night.
Thank you. Good night.
Thank you. Good night. Thank you, Mom.
Bye.
Thank you, Swungile.
Good night.
Thank you,
Good
Swingile.
night.
Good night.
Thank you very much, Mom.
Thank you for the
Thank you,
night.
good night.
Bye.